That's my lord. Both are of WBST.
Both are of?
WBST.
Yes.
State tribunal.
Give all the inclusions for February. It will give.
May I will also kindly just to mention.
Any other inclusion?
No, not inclusion, my lord.
Right.
Item number 146.
Not yours. I'm asking anybody else.
Sorry.
Yes, please. Yes.
Item number 146 of today's list, my lord. This is a matter, my lord, pursuant to your lordship directions. My learned friend on the other side has given an affidavit. They are agreeable to extend the benefits I asked for in the writ petition.
146.
Yes.
You are appearing for the respondent.
If your lordship kindly
can be disposed of.
Yes.
Monday?
Monday, as to be mentioned.
Give. Do you mention Monday?
Yes. Deeply open.
Item number 1.
Lord, in item 1, I beg to appear on behalf of the petition.
Yes.
Malad, this writ petition has been filed with an innocuous prayer.
Innocuous prayer.
Innocuous prayer for expeditious disposal of a contempt petition which is pending before the learned tribunal for the last 2 years. Malad, the order was passed on 22nd July 2022 by the learned tribunal. Malad, the state carried out an appeal after 1 year during the pendency of the contempt application. This honorable court, a coordinate honorable division bench had been pleased to dismiss the writ petition with a direction to pay the amount within 2 months. Well, that has not been. At least 10 days. 10
court's order to pay within 2 months.
No, yes. This honorable court directed.
Where is that?
It appears at page 104. The order starts from
10?
104. 4th September 2023. The relevant portion at page 106, sorry, I stand corrected. It was directed to comply the order within fortnight from date. Review of service done.
What is the last order? Let us see of the tribunal.
My lord, I filed this writ petition on 4th
Last order of the tribunal. Let us see.
tribunal. My lord, the last order, it was simply adjourned. That appears at page 128. Last date was 8th January 2025, my lord. On that day, the matter has been further deferred to April, my lord. Kindly consider. This is after the filing of the writ petition, Dr. Sarkar. Hmm?
So what is remaining now?
Yes, my lord.
The sanction orders have already been given, then what remains now?
Not the entire amount. A part amount has been
Ah,
released.
Whatever it is,
Even then, my lord, the
you
date
have sought an adjournment on this day
no,
for
that is
taking instruction.
all of a sudden this came on 8th January.
Of a sudden,
I shot to get an instruction from my client.
we don't know.
My lord, kindly appreciate.
Revised
The next
pension-
date, my lord, kindly appreciate.
Sorry.
On next date on April, my lord, I am not seeking any prepone. At least, my lord, there would be a direction to
Sorry,
comply
no
the.
direction, sir. It has
My
been
lord,
whatever
that
they have to
the
sanction, they have
contempt
sanctioned.
application at least has to be disposed
If
of by
the-
next date. At least kindly make an observation.
We don't. Yes, heard land counsel for the petitioner and the land counsel for
My
the
lord, I am in this matter, I am appearing for the respondent number 4, my lord.
as well as the land.
Number 2. Program for the petition in this matter. The order impugned as page 128 of the application.
Oh, yes. Yes, which rule you are?
My lord, there is no, I've inquired, there is no rule, and it is their discretion only. My case is very limited to one
You
extent.
have already argued.
Yes, only one line, my lord, my submission. Their decision is under misconception and misinformation
Of what, sir?
of the facts. They say
That is
yes.
irrelevant. It is irrelevant because
Yes.
it causes no prejudice. Ultimately, it is within their administrative discretion.
Absolutely, I understand.
Therefore, an error here or there does not make any
My lord,
difference.
the decision-making process is bad in the
No,
law.
it is not. Show
Yes, I'm
how
showing.
the decision-making
Because
process is wrong.
the decision-making.
You have given a application. They have decided.
No, they said on 2 grounds. They said there is no vacancy, but there is a
Now the
vacancy on
grounds
record.
we are not going to go into. It's not an appellate court.
No,
We are
their
not going
decision
to
is
do-
wrong because they on
All right.
misconception they have taken this decision. The decision-making process is bad. They say there is no vacancy, there is a
Because a
vacancy.
decision is wrong does not make the process wrong. They are two different things.
Yes,
Please try to appreciate.
absolutely, my lord. I bow down to your
Decision
lordship.
making process is a different thing and an incorrect order is a different thing.
Absolutely.
Because an order is incorrect, therefore a process is wrong. That is
Now, what
not
was
a
the
correct statement.
material based upon which they took the
Not
decision?
required. What is the
Is-
adjudication?
It is
There is
wrong.
no
They
adjudication.
did not know that there
It's
is
not
vacancy.
required to be. It's not a quasi judicial function. You have just made an application for consideration of
No,
transfer.
Absolutely.
There is no right which is being
I may be
adjudicated.
rejected. I may be rejected based on
There
fair
is no
grounds.
right which is being adjudicated.
Absolutely, my lord. I may be
You made an
rejected, but
application,
not
they have
on wrong
rejected.
grounds, not on wrong information.
All right.
They say there is no
The
vacancy,
petitioner,
but there is a vacancy.
the learned counsel for the state. The petitioner has made an application for
Which
transfer,
at least I deserve to be considered
Yes.
fairly.
which has been rejected by the authorities. The Learned Counsel submits that the rejection is by taking into consideration incorrect facts. Stop. We had, when the matter was last taken up, we had made a query from the Learned Counsel for the petitioner whether there was any rule requiring consideration of the petitioner's application for transfer to his or her home place. The Learned Counsel fairly submits that there is no such rule requiring or mandating the authority to consider an application for home posting under which the application has been made. The application was made pursuant to certain observations passed by the tribunal in the earlier round of litigation. Stop. The order rejecting the transfer, the request for transfer to the home district or place
My lord, 697 kilometers far away, this lady is teaching.
is
11 years of service.
taken in admittance.
Number 3,
But for the petitioner, my lord. My lord, petitioner, my lord, was engaged as a Tahsil Mohra in the year 1973 and retired from the group duty post on 31st January 2017. And but unfortunately, without counting the previous service of the petitioner, concerned authority has granted the pension benefit and challenging the denial of the granting pension.
Where is the
Counting the
order?
previous
Where is the
service.
reasoned order? Where is the reasoned order?
My lord, count of the impugn order, my lord, last annex, my lord.
Where is the reasoned order 9th March order? Where is the 9th March order?
And
9th March 2018.
sir, 18, my lord.
On 9/3/2018, the Department of Land and Land Reforms considered your application for grant of pensionary benefits and they rejected it. Where is that rejection order? And why you have challenged it after 4 years?
What was actually, but the petition is a aged person has been suffering.
Where is the order?
My impugn order of the state admission tribunal, my lord.
Sir, can you please understand a very simple query?
My lord.
9/3/18, your claim was rejected by the authorities. We are asking you, this is the third time.
Yes, my lord. My lord, page 10, my lord.
Page 10. Page 10.
My lord, P10, my lord, page 32, my lord. My My last page, my lord, 33, my lord.
This is 9/3/2018 order.
90, my lord, 95, my lord.
So if we ask you for a 18 order, you will show us the 95 order.
My lord, that was, my last annexure, my lord, represented 2016, and thereafter, my lord, without giving it response to authority, the petitioner filed an OA application before the tribunal, and tribunal has been without going into the merit, my lord.
9/3/2018 order. Why can't you show us? It will take you all day.
18, my lord. Seventeen.
Obviously, you have not gone through the brief. You have come without going through the brief. That is the whole problem. If you would have gone through the brief, you would have been able to tell us. And it would not take you 10 minutes to either say that it is here.
2018, my lord, from page 23, my lord. Further rejected the prayer, my lord. Page 23, annexure 6, my lord, P6. The additional director of surveys West Bengal, my lord.
Have you not annexed the 9/3/2018 order?
19,
You don't even know what the 9/3/2018 order is.
2019.
Have you even read the tribunal's order?
Tribunal order, my lord.
Have you even read the tribunal's order?
Yes, my lord.
Read paragraph 2 of tribunal's order, sir. What kind of assistance you are rendering? I don't know. We don't know.
Since the respondent had already passed a reasoned order, but there is no reasoned order was passed, my lord.
Come to the order of
Yes, my lord.
2/23.
Since the respondent has already passed a reasoned order,
Yes.
and communicated same to the applicant, the question of directing the respondent to consider and pass a reasoned order is not necessary. But no reasoned order has been communicated, my lord.
Come to the second paragraph. Why are you reading the last paragraph? Problem is you don't go through the brief. That is the whole
Second
problem.
part, my lord, I'm reading the prayer in this application for direction to the take final decision regarding all pensionary benefits to the applicant. The representation of the applicant was also considered and disposed of by the respondent in the Department of Land and Land Reforms on 9/3/2018.
Where is that order? 9/3/2018.
Other than 18, well, 5th March order, March 2018.
We are asking you 9/3. Sometime you are showing a 95 order. Sometime you are showing a 5/3 order. You are not showing the 9/3/18 order. You don't know anything about it. That is the whole problem. If you don't know how you will assist
And
us.
9/3, 2018, where no reason order has been passed, madam.
So you have said so, that on 9/3/18 no order has been passed. Where have you said in the writ petition that no order has been passed on 9/3/2018?
That's why I'm challenging.
Where have you said in the writ petition that no order has been passed on 9/3/2018? Show us. That's what we are asking you. Where is the order? Either show it or tell us that you have taken a ground that there is no such order. The tribunal has recorded a wrong fact. You are taking us to unnecessary different documents which are irrelevant to the court's query. So from where this date, the tribunal has got this date of 9/3/2018. Where is the OA filed by you? Where is the OA? Why you have not annexed the OA? Why you have not annexed the OA?
My lord, yes, the last answer, my lord. Order of the tribunal, my lord.
Where is the OA, sir? The rules requires you to annex the OA. Why you have not annexed the OA and WS?
No WS was given, but
No WS was given.
yes, my
You say anything, that's the whole problem. You are just saying anything, responding off the cuff. That is the whole problem.
but give a liberty to annex the OA application.
Why liberty is required? You are required under the rule to annex it. Why have you not annexed it? Why? You file a writ petition just like that, casually,
And kindly give a leave to annex the OA application.
not today. You do whatever you want.
But paying for leave to annex the.
Sorry, then I will impose cost because your petition is not in accordance with the rule. If you want liberty, then I will impose some costs. No casual attempt. You do it by Monday. Not today is enough.
Good for you, lord.
Item number 4.
Lordship, I am not in this matter, Your Lordship. I have been told by Oshmita Chakraborty, learned advocate clerk, that she is not present today.
You are for
I am not in this matter, Your Lordship.
Sir,
I have been
mentioning on whose behalf?
state, Your Lordship.
All right, let him. Yes.
But we have approached the honorable court at an interim stage, my lord. The last impugned order records, my lord, the adjournment of the proceedings because, my lord, there is no division bench functional at the tribunal. And the issue, my lord, involved in the original application before the tribunal is that, and whether we are entitled to work up to the age of, my lord, 65 years.
You are working as?
Workshop instructors. Now, my lord, the state government had recognized our status as teachers. Since, my lord, the state government has issued notification that the age of teaching faculty of, my lord, the polytechnics across the state will be 62. We are claiming parity of the same. And I must inform your lordships, my lord, while the matter was admitted, we prayed for an interim order. Interim order was refused by the tribunal. We approached this honorable court, and the, my lord, honorable court was pleased to dismiss, my lord, the writ petition. So there is no interim order as of now. My lord, in the meantime, some of the applicants have also attained their age of superannuation, and about, my lord, 10 of them are will be soon approaching their, my lord, age of retirement. And that is the urgency, my lord. Unless the tribunal hears out the matter in full, my lord, the original application will become infructuous.
You will keep approaching the High Court.
And
Once
we are,
it has
my
rejected,
lord, we are,
again you will approach the High Court.
my lord, we are remediless. We have prayed that let
You are remediless against the tribunal's order or tribunal's pendency. You were not remediless against the rejection by the High Court on the last occasion. You had your remedy.
yes.
You have chosen not to avail. You have
And-
chosen to wait. So every day somebody retires, you will file a fresh IA.
My
or a
lord,
fresh
we
writ
we have
petition.
prayed in this.
Where is the earlier order passed by the High Court?
And in this writ petition, we have prayed for hearing by this honorable court because the tribunal
Where is the order passed by the High Court earlier?
Page, my lord, 128. And in this order, the honorable court also directed the tribunal to hear out the matter.
So therefore, we'll again direct. If they don't do it after 1 year, you file another writ. Again, the writ court will direct.
My lord,
Let's try to understand what the court is observing.
my lord, I understand because the
Please, as a counsel, you assist us. Is
Lord-
this the way to be done?
There is no
So
bench.
every 6 months you file a writ petition and we will issue a direction to dispose of expeditiously.
There is no tribunal, in fact, in the eye of law.
It is not a new thing. It was there before the High Court
Yes,
when you moved it on the last occasion.
Lordship. Lordship may dispose of directing, the.
No direction, sir. It is not maintainable again for the same relief.
I have not prayed for any interim order this time. I have prayed for expeditious disposal or hearing by this.
Cannot be. What is the, let us read the last order.
The last order, I have annexed the certified copy, and it's at the last enclosure to the writ petition. They have not even filed the rejoinder. Sorry, reply.
Yes.
Bill 5720. First order 57. Thereafter, the matter was taken up on at page 130 on 6/12/2023. Then again on 1st of April 2024. And then again the last order that I have enclosed the certified copy of. And order dated 28th November 2024. The reply is not filed by the state. How will I file a rejoinder? Rejoinder is by the applicant side. Reply is by the state. The last paragraph. Since no bench is available to let this matter be placed before a bench comprising of 2 members, judicial and administrative, under the heading hearing on such and such. 25. Reply rejoinder, if any, in the meantime. Both have to be filed. And if your lordships kindly takes up at the very first minute, page 70. And this is a notification by the government of West Bengal. And may I place the last paragraph of page 70. And having regard to the nature of duties assigned to the workshop instructors, and in consideration of the fact that these instructors have actually to perform teaching duties by imparting practical training in workshop to the students of polytechnics in absence of any other qualified teachers, it has been decided by government the workshop instructors of the government polytechnic should also be given the status of teacher. At next page, the undersigned is accordingly directed by order of the governor to say that the governor has been pleased to order that the posts of workshop instructor now in existence in the government polytechnics of the state should be given the status and should be given the status of teacher on their existing scale of pay with immediate effect. And we are recognized as teachers by the state. Next, that kindly takes up page 113. That is the opinion of the tribunal that fell from the tribunal that it has to be gone by a DB, and I was not. That is practically a. May I submit that? We. I have had the past experience of making the submission. It was not recorded. We came up to the High Court. Even the High Court refused to accept. Believe us. Believe our prayer. And that is the. That is. I know. I have to. I have to place before the tribunal that. What after the tribunal observes that it has to be placed before the division bench. As per records, my consent is there. Yes, yes, yes. I cannot say. May I just. I cannot submit. That is why I said I should not make that submission. If your lordship takes up the relevant notification based on which the tribunal is taking. Then kindly grants me liberty so that I can move that application there.
Item number 5.
My lord, in item number 5, we are for the petitioner, my lord. My lord, we are paying for short passover, my lord. Senior counsel is just coming, my lord. Wait for the petitioner, my lord. Hearing, my lord, hearing is very necessary, my lord. Petitioner, sir, here, my lord. Hearing is very necessary, if my lord kindly. My lord, if my lord can happen. My lord, if my lord half an hour, my lord. My lord, in my 15 minutes, my lord, is passed, my lord. Already. No, there is file, my lord. But if my lord permit 15 minutes, my lord, senior comes. Then my lord, not, then, my lord. Then, my lord.
Item number 6.
This is my application. My lord, kindly come to my impugn order. No reason has been given, simply sit on the basis of an larger bench of the tribunal, my lord, which order has already been stayed by the Supreme Court, then SLP preferred by the Union of India, my lord. Despite that, my lord, no opportunity was given to the petitioner there, my lord, to file opposition and pass the order asking to pay, my lord, lifetime area in respect of disabled pension, my lord. 40% was initially was, my lord, date of order is, my lord, 8 March 2019. At the top, my lord, my lord, kindly come to after page 98.
Yes, I have seen that one. Kindly see. This is a covered, because my lord, this is a, so that is, no, that is because it is a, let me say. Nobody appeared. My lord, the OIC legal cell was there.
The tribunal is specific.
My lord, the
Please
representative-
hear what we are saying. The tribunal specifically records no affidavit in opposition is being asked from the respondent as this is a covered matter.
Covered matter. Very well, my lord.
If
that-
clear-
see the,
Just come to the procedure for rules for the hearing before the tribunal. Come to it. We are only on this aspect. We are not on the merits of his claim. Come to this, come to the rules of procedure.
that my lord is right, my lord. First
How
we
can
have
you do it?
affidavit in
At
opposition,
least
then
one opposition they should have been allowed to. Then whatever on merits, whatever order.
present.
Oh no, don't say that, please.
Yes.
No, no. Please read the entire order, then make submission. Come to the last page of the order.
So, my lord, see.
Please come to the last page of the order, paragraph 9. Don't say nobody was there.
Previous page, just see the previous page. my lord.
Please read paragraph 9. You are relying on the order.
Respondents have all pleaded that they be allowed to.
Don't say that there was nobody.
Before the Supreme Court.
So don't say there was nobody there.
Hello?
Don't say there was nobody there on behalf of the respondent.
That is the representative of OIC legal cell. There is a major or a lieutenant colonel who is posted there, who is from the government side, who is always present, my lord, in the case.
The respondents were there.
So this, if you see the first page, just page before the page he is quoted, because he is not given the page number here.
In-
99, just see page 99.
If that name of the council is not noted, then that will not erase paragraph 9 of the order. That format in the front will not erase the contents of the substance of the order.
It is for your consideration.
We are only asking you on this aspect.
Yeah,
Why
I
such?
got it, my lord, but I'm just saying it is for you. I've got it. My lord's mind I have got, my lord. It is for consideration. The widow of a brigadier is
We are not on
93 years old.
merits. We are not, had the matter be decided on merits, we would have gone into merits. It has not been decided because no opportunity was given.
My lord, it is a lifetime.
How can a forum say that I will not give any opportunity? We don't know. We are not on that issue. As much as you may try to take us there, we are not willing to go there. We are only on the procedure. Look at this failure of natural justice by the tribunal. No opportunity. You specifically, it is recording that we don't want any.
And thereafter they said they'll go to Supreme Court, because in those days it was Supreme Court. my lord. In those days, the Supreme Court was, but they have not done anything. Thereafter, I filed an execution petition.
You have filed?
I filed an execution petition, my lord, on this. Execution petition, and in the execution petition, my lord may see the order dated 30 September 2020.
Where is that?
Order dated, where they are saying, yes, we will implement the order. And thereafter, they have changed their mind. U-turn. Because now it is allowed here.
Oh.
And my lord will come before this forum after 5 years. There is a delay of 5 years plus.
My lord,
What is your stand in the writ petition? Why you have filed it after 5 years? What have you said?
my lord, in this aspect, my lord, we have stated in paragraph 8 and 9 Because, my lord, there are many things has to be done, because by that time, my lord, what happened? My lord, when the matter was taken up by the tribunal, my lord, in 2019,
We are asking you what you have said in the writ petition. Please take us to the relevant pleadings.
my lord, kindly come to, my lord, para 8 and 9.
We are asking you what you have said about delay.
Well, delay, I have said, my lord, regarding first question, my lord, the execution petition, we are defending there, my lord. And then, my lord, the file was placed on different, my lord,
Where is that? Let us see.
para 8 and 9, my lord, of my petition.
Para
Paragraph
8.
8 and 9, my lord.
8 and 9. It's 6.
My lord,
Which page? Which page?
Page 6, my lord, page 6. Page 6, paragraph 8.
There are two paragraphs 8 and 9. There is a paragraph 8 and 9 before that also. That is without any paging.
My lord, the page number.
Now we have got it. Yes.
Para 8, 9. Page 6. Page 6 है सुनो। 6 नंबर पता है सुन। नहीं।
What is this broadbanding? Please explain the
Well, broadbanding is that, my lord, the subsequent circular was issued by the government of India, my lord, in a case, my lord, where they have been expired after 1196, my lord. Then, my lord, disability pension was initially granted 40%, is extended to 50%. Now, my lord, in this case, he was expired in 2000, my lord. He was
We
expired.
are asking you what is broadbanding.
Broadband is that, my lord, he is asking.
Where is it? Where is this term defined?
Well, it was a circular, your lordship will find at page, my lord, page 53, my lord.
Even in the regulations, man.
Please. Oh, there is. It is there in the regulation.
Yes.
Yes.
Page 102.
Page.
Page 102.
कोर्ट को सेटिस्फाई कर लिया उनका बात करना ब्रॉडबैंडिंग उनका सर्विस find this expression.
We don't find any such expression being used in the regulation. We don't find such expression in the regulation, broadbanding.
Previous page it will be mentioned that if it is less than 30%, more than 20 and less than 50, then it is rounded off to 50 malak.
So that rounding off is called as broadbanding.
Exactly.
Kind of approximation. Approximation. Less than 5 will go to the lower figure and more than 5 will go to the.
It is always higher.
Always higher. In this case, always higher.
20 and 50. Supposing it is 30, then it will be 50. 40, then also 50. Then beyond 50, again it is 55 or something. Then it comes to 60. And then 75 is also given. If it is 60, then it goes to 75. And then beyond 75, it goes to 100. That is
In this case, the widow was a beneficiary, the deceased was beneficiary of 30 to 40%.
40%.
30%.
40%, my lord.
by broadbanding is 50%.
It will come to 50%.
Yes.
They are not disputing that. They are just saying the areas when it is to be given with effect from which date. The
Yes,
only
sir.
dispute is areas with effect from which date.
They have given
Whether
complete
whether the claim can be for a period beyond 3 years or not.
Yes, ma'am.
That is the only issue.
That is the issue. Now on that they are saying that we have.
Now let them say yes.
My lord, 13 January 2014, the deceased employee expired. The application made subsequent thereto in 2018. My lord, by that time, my lord, several years has gone. Now, my lord, as per Supreme Court judgment, I have annexed with this writ petition, my lord, there, my lord, it has been categorically stated that he ought to have obtained only 3 years, my lord, that the
Let us
pension.
see. Let us see.
My lord, kindly come to my lord, page, my lord, 85. The judgment starts, my lord, there. My lord, para 10 and 11. May I read, my lord? Page 88, my lord, paragraph 10 and 11.
Why are you referring to a judgment which is of this is of which date? 2007. Why you are referring to 2007?
My lord, because, my
There
lord,
are letters of 2009 and 10 which the tribunal has relied upon, and you are referring to a decision of 2007.
question is that, my lord, we have not obtained any opportunity to cite this judgment to the tribunal. My lord, that apart, my lord, one judgment of Supreme Court kindly takes up, my lord, this particular aspect referred by, my lord, some other state, my lord.
Government of India Ministry of Defence letter of 13th April 2016
My lord,
and 15 September 2014.
my lord.
Any judgment that you are relying upon has considered these two letters.
My lord, kindly come to page 94. The SLP preferred it was stayed. The
Page?
tribunal order, my lord, page 94. My lord, kindly turn the page. Kindly, my lord, turn the page. Page 95.
This is the complete order.
No, it is, my lord, interim order has been passed. Then, my lord,
This interim order is complete.
yes, my lord. My lord, the SLP is pending before the Honorable Supreme Court, challenging the large judgment's decision of the tribunal. And, my lord, this order was passed, my lord, kindly sees, my lord, 13 July 1918. And the tribunal passed this order in 19. My lord, had that been a case, my lord, we are there, we could have apprised the Honorable Tribunal, my lord, saying that this is the order passed by the Supreme Court, staying the all further proceedings in respect of the, my lord.
This is a stay in which case?
In case of, my lord,
Sergeant Girish Kumar.
Girish Kumar, my lord, similar
It has
issue.
been referred to by the, it is one of the decisions referred to by the tribunal.
No, it has not, could not place it because we are not there. Well, had, my lord, this question, my lord, was no.
Sergeant's case, whether it is similar to this person or not, how do
Yes,
you,
my lord, similar, my lord, similar.
how do you say that?
My lord, kindly last line, if you lords will consider, my lord. However, learned additional Solicitor General says that he will advise the Union of India to release the disability pension for a period of 3 years prior to the date of filing of the original application before the tribunal or the date of retirement as may be applicable.
But that doesn't show that it is the
Then,
same.
my lord, opportunity should be given. I shall bring the, my lord,
This
enter
does not show-
file. I shall bring the file, my lord, so that I may apprise to your lordship, my lord, the similar issue was pending with the Supreme Court. And this order passed in 2018, July 2018. And the tribunal order passed in
Maybe passed yesterday,
my lord.
but the point is whether it covers the facts of the
My lord,
case
my
which
lord,
we
my
are
lord,
considering.
my lord, I'll place it, my
That
lord,
is
kindly.
hardly relevant that when it was passed.
Yes,
We
but
can't say from this order that this order is that.
my lord, last
you
two
not-
line, I think, my lord, subject to your lordship
No,
correction, my lord.
That is such an inference cannot be drawn.
Then, my
That
lord,
because there it has been directed, therefore in every case in the country it has to be directed.
my lord,
We
kindly,
don't know what are the facts and
my lord,
circumstances.
kindly then give me some time, my lord, so that I can bring the, my lord, enter file of the SLP, my lord, so that I can place it before lordship, my lord.
When you are relying upon it, you must have narrated the facts in your writ petition. Have you said anything how it is similar?
My lord, it has been stated,
Where have you said about
I have
P6?
stated, my lord,
What have you said about P6? Which
my lord,
paragraph?
para 8 I have stated,
Come to paragraph 16.
sorry, my lord.
Come to paragraph 16. Oh, yes, there is a specific averment to that. You file an opposition, we'll see. You file your opposition, we'll see.
Well,
Let the, you will record your appearance,
yes, madam.
Mr. Swenson. Seen.
160. Now, these two, my lord, these two judgment which he has next, they relate to if there is a delay in filing an application. In this matter, there is no delay in filing an application. The husband died. Thereafter, the applicant corresponded with the authorities, and when they gave the final order, that is the time OA was.
So we'll see.
OA was.
Meantime, the
I'm just satisfied, my lord. Right now, I didn't know.
by filing an opposition.
But look at the judgment is also annexed, my lord. Fifth class is
They are saying that it is on the same set of facts and circumstances.
not
There has to be a denial. Otherwise, how can it be? Please try to understand what we are saying. Unless you deny it, the paragraph 16, where is the question of examining the
Page
issue?
94 দেখুন, page 94
Therefore, we are giving you an opportunity. In the meantime, the court is of the opinion that the order of the
Grateful, my lord.
Item number 7.
Lordship, I beg to appear on behalf of the Petitioners Union of India in this matter, Lordship. Lordship, I'm aggrieved by an order, impugned order dated 2nd of February 2024, passed by the Tribunal, Lordship, wherein the Tribunal has set aside the minor penalty imposed against the respondent for a proven misconduct, Lordship. If the Lordship can kindly takes up the impugned order dated 2nd of February 2024 from page 242 it starts, Lordship. Straightway, Lordship, I'll take you to Lordship, page 251, Lordship, paragraph 5.3, Lordship, 250, Lordship, page 250. Lordship, the only limited perspective, Lordship, the only limited perspective, it is an admitted position, Lordship, kindly appreciate. 1 year. Lordship, it is an admitted position that the punishment which was imposed against him, the minor penalty, it was Lordship, 1st of July 2017, Lordship, 17, and he superannuated on 30th of June 2018, Lordship. Admittedly that minor penalty has a cumulative effect on his pension, but at this stage, what appropriately the tribunal could have done is that, Lordship, to remand back the matter back to the authority, back to the competent authority, in order to justify the penalty which was imposed on him, and not to set aside the entire penalty against which there has been a proven misconduct, Lordship. I would like to place reliance on, Lordship, the larger bench decision of the Honorable Apex Court, Lordship, in BC Chaturvedi's. Lordship, I am on that. I am not on that. Lordship, I accept that. Lordship, I accept that. the only limited perspective of my challenging this impugned order, Lordship. Lordship, that 1 month, if had it been the increment which was due to him, had it been the date of such increment would have been in the month of August, then the purpose would have sufficed. But in this case, Lordship, no, my limited understanding, Lordship, is that while adjudicating this matter and while deliberating this judgment of 2nd of February 2024, Lordship, the tribunal ought to have, Lordship, kindly appreciate, one factor remains that he has been punished for an offense which has been proved against him, Lordship. So that remains, Lordship. It is not my case that the punishment is way more than, or rather, there were no material against him. That is admitted. But the punishment, the minor penalty which has been given, has a cumulative effect which has adversely given effect to his pensionary benefits. Now, only
Has a cumulative effect. No, it is without cumulative effect.
without cumulative effect, but has a effect on the
Of
pensionary
becoming
benefits.
cumulative, yes.
On the pensionary benefits entitled to the writ petitioner or the respondent, Lordship. Now, the only thing is that while considering that particular factum, the tribunal, based on it is a settled principle of law, Lordship, the tribunal ought to have remanded back the matter.
Why? How can anybody claim a right that it should be remanded back?
Lordship, because the
It is for
competent
the
authority, the
forum,
disciplinary authority,
It is for the forum to decide whether it will interfere with the order
it could have,
or leave it to the authorities to decide.
Lordship,
You
it could
cannot
have.
claim a right that it must be
No,
remanded.
I am not claiming as a right, as a matter of right, Lordship.
It should have been
But
remanded.
What the tribunal has done
If you
is
have
that
fallen
they
in error, then the tribunal will do what it has to do. Why not?
Lordship, but kindly appreciate, the tribunal has set aside the whole minor penalty itself. Against a proven misconduct, the tribunal has not only, it has a substantiated a different penalty which doesn't have a cumulative effect on the pensionary entitlements, but it has set aside the whole.
What was his prayer before the tribunal?
Lordship, that Lordship will get at.
He has assailed the order of punishment.
Yes.
He has assailed the order of punishment.
Lordship.
He has not accepted it. So the tribunal has not interfered with the punishment.
Tribunal has not interfered with the punishment. Lordship, can kindly takes up page 250, paragraph 5.3.
Yes, that's what we are reading.
Lordship. And the reason with the pensionary entitlement is at paragraph 5.4 at page 251, Lordship. Lordship, I have already served notice, Lordship. I have filed my affidavit service, Lordship. Your Lordship desires, I can again serve a fresh notice upon the instrument petitioner, Lordship. 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 Lordship, since he was at that relevant point of time, he was in service at the ordnance factory. Lordship. He was a.
This was filed before his retirement
This was filed before the tribunal. Yes, Lordship.
because it's of 2017.
2017, Lordship.
Serve again, let's see.
Lordship.
Affidavit of service is taken on record. We are of the service and affidavit of service both. Let affidavit of service.
Item number 8.
Then you would have got it. Not become due. So the punishment has no effect.
Impugned order, rejection kind. And impugned order.
Served.
Yes, my
Yes,
lord,
sir.
sir.
Served.
Sir.
What is the issue?
No, this is, my lord is aware about the issue. This is with regard to the disability pension in the army. Now, in this case, order has been passed, the judgment has been passed based on the earlier regulations, which is the 1982 regulations, where the question of presumption was there. 1982 regulations was in vogue at that point of time. That judgment has been relied upon by the tribunal and an order passed, whereas the regulations that were applicable were the 2008 regulations. What are the correct
Date of the judgment, tribunal's judgment.
My lord will kindly see page 168, date of the judgment. 22nd July 2024, my lord. So, my lord, the crux of the matter is that in the earlier regulations, the presumption was there, and in the 2008 regulation, presumption is not there, specifically omitted by the 2008 regulation. Whereas the Supreme Court judgment that has been relied upon by the tribunal, Dharamveer Singh, relates to the 1982 regulation. And the facts of the matter relate to
Presumption, why presumption?
I will show, allows me to show
There
that
must have been a release board. So
all
what is the finding of the release medical board?
finding of the release.
Where is that? Let us see.
Yes, madam. Well, before that, may I show the rejection part first?
The rejection will be considering the release
Yes,
medical board.
I will come to that one by one.
Therefore, let us see the all right.
Yes, madam.
I will kindly come to page 56, which is the rejection, and thereafter the next page is the release medical board. My lord, may I please? My lord, may I place paragraph page 56? My lord? Specific है. Specifically at page 65, the release board reasons are given. When is the left service? When is the left service? When is the left service? 850. 91 to 2020. Hmm. Oh. Hmm. Similar matters में stay हुआ है वो order को. Research. Research. Programming.
है ना? सुना सर? बैठ गया पूछेगा Where is a 24 day वाला चक्कर और काम का 14 डे हाँ मार्क किया हुआ है लेकिन वो कहाँ है भी सेम 14 डे सर्विस and stream of service start. This comes from which guideline? But 14 day chapter कल भी पूछा था मैं बोला that comes from 14 day chapter comes from
Yes.
my lord. My lord will see that at page 65
He was admitted with the condition in October 2020.
my lord.
He was admitted with
Yes.
the condition in October 2020.
Yes.
Now, whether it was attributable to service, for that you are required to examine 14 days
That
duty
they have
chart.
that they have done
Of for which period?
for my lord will kindly see the 14 day
14 days to precede the date of his admission.
they have already given that in the medical board.
The date of his admission in
My lord,
October
I'll-
2020.
my lord, I'll show you. Please, medical board, page 74. What is that weird? Yes, my lord will kindly see page 74. Madam. The dates were these. Immediately preceding the period
74.
Page 74.
What is this?
My lord, this is the 14-day charter report. It starts from 3rd October and ends at 16th October, which is at page 78, my lord.
3/2/21, where is the communication of this 14-day?
My lord will kindly see before that, this is appended.
3/2. See, please come to page 113 first, 113,
Page
113.
113.
There is a tabular form there.
My lord, just. Yes, my lord. Yes, my lord.
In the last column, it says, due to no evidence of infection, trauma, and exceptional stress and strain of mill services
In the 14-day charter of
of
duty.
duties dated 3/2/21. Where is this 3/2/21?
3/2/21. My lord will kindly see page 78.
Oh, so this 3/2/21 is the date on which it has been sent,
Yes,
but it is for the correct period.
for the correct period. For the correct period. Now, in my lord, in similar matters, my lord, this court has admitted the.
So what has the tribunal? Let us see what the
My lord,
tribunal has.
my lord, will kindly see the impugned order, which is at page 168. Tribunal did not go into the merits, etc. Straight away went into the law, and the law that the tribunal applied was Dharamveer Singh.
When we are reading, can we hear you?
I'm extremely, I apologize, madam.
So under, you are saying that it should not have been considered under the 82 rules.
My lord,
Then under which rule?
2008,
Let's see.
2000.
What does it say? And how does it,
There
what,
is only one. The crux, my lord has to see only one. This is 2008 and
so
2000.
Dharamveer Singh judgment is in respect of 82
82.
rule.
82.
It isn't after, it's not after 2008.
No, the judgment is after 2008, but it relates to the issue which is before.
Where is the judgment? Let
I'll
us
just show the judgment as well as the these are the entitlement rules 2008. Entitlement rules 82 इधर. हाँ, मेरा कॉपी है ना? हाँ? हाँ, ये है 82. Well, these are the regulations 82.
What is the difference? Let us.
I'll show. There's one specific.
5 and 6.
5 and 6. Yeah, 5, no? ना सरका इधर इसमें निकालो. My lord is seeing the 82 regulation. My lord will kindly see 5 of 82.
Yes.
My lord has seen the in the 82 regulations, my lord. 82 regulations specifically say that the approach to the question of entitlement to casualty pensionary awards and evaluation of disabilities shall be based on the following presumptions. The presumptions were that prior to and during service, a member is presumed to have been in sound physical and mental condition upon entering service, except as to physical disabilities noted or recorded at the time of entry. B, in the event of his subsequently being discharged from service on medical grounds, any deterioration in his health which has taken place is due to service. So there is a presumption that he is completely healthy based on those tests. My lord will now kindly see the 2008 regulations. 5. This has presumption.
4B. 2008 read 4B.
Yes, my lord. An individual who is bonded out of service on medical grounds before completion of terms of engagement shall be treated as invalid from service.
Shall be treated as.
Yes.
So there is no substantial difference. There also there is a presumption here also 4B. He says he shall be treated as invalidated from
But
service.
my lord will see. And
Now come read 6 with that.
Yes, my lord. Casual connection.
Yes.
Casual connection was there in both. Casual connection is
So
there in
there
both.
also there is no difference.
It was there. There is no
Now
difference.
on who the onus of proof lies, read
Yes,
7.
It's 7. Onus of proof. Ordinarily, the claimant will not
Be called upon.
Yes.
Yes. So
Yes.
it is
So
for you to establish
that
there is no casual connection.
that we have established, my lord, through the experts release.
There is no substantial difference in the rule.
Only specific because, my lord, the only
There also
there's
it
no
says instead of using the word presumption, here it says will be treated as. There is
my lord
no-
will kindly appreciate.
There is no difference.
There is a reason why these new regulations
Have
have
these
brought in
two
this.
rules been considered by any judgment?
Not yet, my lord. Not yet.
In Dharamveer,
There are plethora of matters pending before my lord. So there are, because for this reason, admissions have been made in most of the matters, and my lord, the matters will come up before
so
my
you
some
address us, we'll hear you. We'll hear you. We don't find prima facie that there is any difference. The wording may be different, but the
my lord,
object and intent of the
I
rule
will-
remains the same.
I will place my argument, but on that. But my lord, subject to correction, my lord. My lord is saying invalidation from service.
Yes.
B, an individual who is boarded out of service on medical grounds before completion of terms of engagement.
Yes.
And here, the situation is not that. They all situations where terms of engagement have been completed.
What do you mean? They have retired?
Yes. Superannuated. Superannuated. Just before that, this is the question of the terms of.
Sir, before that means even if there is one day before that, it will be treated
No, no,
as
no.
boarded
No, that
out.
is not the case. In the usual course, they have.
What was the date of retirement of
My
this
lord,
gentleman?
My lord, I'll show.
What was the date of retirement of this gentleman?
My lord, my lord. My lord will see the release medical board.
No, please tell us.
I will
Give us the date.
Yeah, no? 28 February 2021. My lord will kindly see page 57.
Yes.
My lord will kindly see page 57. 28
Give us the
February.
date, sir. We did not.
28 February 2021.
28th February
Yes, 2021.
is his date of retirement.
Day of retirement release.
Yes.
So he completed he was on low medical and he completed in 2021.
He fell ill in October.
Yes.
What was his due date of retirement? We are asking you. We are not asking you his retirement, release retirement.
No. My lord will see total service 30 years, 2 days.
How does that make a difference? There is an age.
No, my lord. It was for 30-year period. Para 21, page 10, my lord will see. Page 10, para 21. I have pleaded that. And it is admitted also. It is not. on completion of service. My lord, you see the fourth line?
Para 10 page 21. Oh,
Page 10, my lord. जरा निकाल दो, आर्मी रूल वाला निकाल दो। One page निकाला। 33, 33. Rule 33. इसका कॉपी है।
because you have not conducted the release medical board. You have delayed it. You cannot delay it and then claim advantage of the delay and say that he has crossed the.
So, my lord, these are the bunch of matters all have the releases are release medical board has to be after that. When he release medical
When he
board
has
will be after-
reported back to you and you have put him on a lower medical
Yes,
category,
yes, my lord.
then at that time you are required to conduct the board. You have not done it. Your competent authority has granted extension
He has never asked,
months.
my lord, he has never asked for release.
Where is the requirement of
He has never-
asking? Where is the requirement of asking? Show us.
No, not for release. I am not
He
releasing
has
him.
not asked me.
My
So
lord,
where is the requirement
No, my
of
lord,
asking?
I am not releasing him. I have not
You
released
are
him.
not you are not subjecting him to the review.
But
Then
he was in service.
what do you mean service?
He was in service, my lord.
You cannot gain a benefit out of delaying the release medical board. You cannot. You have
My lord,
delayed
my
it
lord will
for
kind,
months.
my lord will kindly
He was
appreciate.
treated in October and you have done his medical board in February.
My lord, all the data that has been considered by the medical board. My lord will kindly see the medical board report once more. Release medical board report 57, 58. Every detail has been given. It's not that any advantage is being derived.
Delay itself
How,
is
even
defeating his claim.
even hypothetically,
Delay itself will defeat his claim under the rule.
my
Because
lord, even hypothetically, even if
otherwise, if you had conducted the board
yes,
in October when he was admitted for treatment and when he was discharged, then a question whether 4B would apply or not would arise at that time itself.
it's not that I want to take advantage of 4B, which is why my lord,
Obviously,
because after that he has
Obviously.
continued with his service.
sir,
He has his service
he
left.
was on sick leave for 8 weeks, 11,
Yes.
8 weeks.
Yes, yes.
He was on sick leave.
But can I conduct the release medical board then? I can't conduct the release medical board then.
That
Release
will
medical board.
That will consider whether your delay will inure to your benefit
My
or your delay will defeat his claim,
not
which
only that,
arises under 4B. And
my
whether
lord is
the army
looking,
should be doing
my lord
this.
is now looking into the merit part.
Yes,
Merit part.
obviously.
So when my lord will consider
We are
matter
considering.
in detail,
We are
merit
considering.
part. Now the question is, today this has not been considered by the tribunal.
Huh?
Today this has not been considered by the
We are
tribunal.
considering it.
My
You show
lord
us
has
whatever
all
you want to
powers. Now my lord will have to see whether the delay is intentional or not.
All right. So tell us.
Intentional or not. There cannot be any question.
Where is the order granted by the competent authority for extending the date of review medical board, release medical board?
My lord will kindly before that come to page 112. This is our opposition before the tribunal.
She was discharged from the command hospital on, we have gone through this on 22nd January. 23rd, he again came from medical board. Again, that day it was not done. And then he has gone. And then you have sought extension for conducting the.
No, my lord, we have had it in February only.
So let us see where is the extension, on what ground the extension was granted for his release medical board.
The
How
petitioner,
the competent authority has granted the release, condone the delay for holding the release medical board. Because release medical board is to be conducted immediately. If you don't, then a condonation is required to be done. So on what grounds the condonation has been done? Let us see.
my lord, that has also been said.
Where is, let us see the order, forget about what has been said.
My lord, that is not on record.
Please
Then I
show
have
us.
to. Page 1, my lord, sees 124. 124, no?
Sanction is hereby
My lord, this is
recorded
it.
of the competent authority. Where is the competent authority's order?
The sanction of the competent authority is hereby accorded for condition for condoning delay for holding delayed or belated release medical board
Where is
after
it? Where
discharge or
is-
release from service in respect of the
Where
following.
is that? Where is that competent authority's order? Where is it?
We have on record here, we'll give a supplementary affidavit. Do we have on record here? Yes, now this is. Yes. Is it on record here? My lord, this is not on record here, we can produce it, my lord.
Bring it.
I will.
Minute counsel for the petitioner.
We come to that, my lord
Minute
wants to
counsel
see.
for the petitioner. See, come back after 2 weeks. 2
Item
weeks.
number 9.
No, my lord, 2 weeks probably.
Much before 11th February. Yes.
7th, I
Call the
think.
next.
Your Lordship, I am praying for not this week because the learned counsel arguing the matter due to his
Wait,
personal
Just
difficulties.
after 1 week. As paid by learned counsel for, you are appearing for the respondent. In presence of the respondents, as paid by learned counsel for the petitioner.
8,
That is
9,
adjourned
10,
for
11,
1 week.
same counsel is
All
there,
right.
Your Lordship. Sincerely obliged.
You are appearing in all.
No, only for 9, 6.
No, right now we have taken up 9. So only in this. 8 has already been argued.
6 and 9.
9, 10, 11, Your Lordship.
You are not in 10 and 11. You are not appearing in 10 and 11.
No.
Anybody is appearing in 10. Give your appearance in presence of learned counsel for the respondent as paid list after 1 week. In 11, nobody's appearing. Call 10, 11. Call 11.
Item number 11.
Yes. All right. Simple as prayed by learned counsel.
May I beseech your lordship for item number 10?
Call the next case.
Item number 12.
Your lordship, I'm humbly praying for only not today, your lordship,
Yes, not today.
grateful, your lordship.
Item number 13.
Madam, for the petition, I'm also paid for not today.
Yes, not today.
Item number 14. 15. 14. Item number 14.
14, sorry. Lordship, in this matter, I'm for this petitioner.
Yes.
কিছু চাই না, শুনছি আমি শুধু কিছু না।
My lord, we want to withdraw the application.
as prayed by the learned counsel for the petitioner. The writ petition.
Number 15.
মাত্র 8 চলছে।
হ্যাঁ ওরা মানে এ নিয়েছে ওরা passover নিয়েছে যারা petition today guys appearing for the respondent. I'm only praying for not today, your lordship.
My lord, same here, my lord. Mr. Kaushik
Not
Dey is
today.
appearing, my lord.
Not today.
In 15, 16, and 20, my lord.
15 not today. Call the next.
Item number 16,
Same parties. All right. Not today.
17,
I will be hearing my not today, my.
You are for?
I for the petitioner.
All right. Not today.
18,
I pray to appear on behalf of the petitioner in this matter.
Yes. Give the file.
My lord. My lord, in this matter, the petitioner is aggrieved by the acts and actions of the railway authority, wherein the petitioner was not allowed to resume his duties as a Group D employee.
Resume after.
My lord, the petitioner was absorbed in Group D in the year 2006. And from 2006 to 2013, the petitioner was in his service. In 2013, the petitioner got ill. The petitioner was affected by pulmonary tuberculosis, and subsequently the petitioner sought leave for a period of 6 months primarily, and then for another 2-3 months. Subsequently, when the petitioner went to join his duty, the concerned officials challenged his identity. The petitioner was asked to come along and give proof of his identity by verifying the various parameters in accordance with the railway rules. The petitioner went there. The test had never been conducted, and the petitioner is out of his service and is on the verge of his retirement, my lord, with a flux of time.
Lordship,
My lord, may kindly seize page 19 of my petition, my lord.
Yes, what is the infirmity in the order?
My lord, so far as the case of the petitioner is concerned, my lord kindly sees page 19 of my petition. This is the primary document wherein it has been certified that the petitioner herein, one Digambar Mondol, he was suffering from pulmonary tuberculosis and was advised for bed rest of at least 6 months.
That's not the issue, sir. You probably know what is the issue.
My lord, my lord.
What we are asking
lord,
you what is
my lord.
infirmity in the order.
My lord, the fact is that the petitioner went there to get his identity verified. The identity had never been verified, my lord. That is my grievance. I have been laid off without citing any reasons whatsoever. The authority is saying I am not the same person.
So on which dates you went for the identity verification?
My
Give
lord,
us-
I'll indicate, my lord. I'll indicate. My lord, I went on 8 February 2016.
Yes.
My lord, on 8 February 2016, that is Annexure 13. I'll indicate the page number, my lord.
Annexure 13.
Annexure 13. My lord, I'll indicate the page number. That should be Annexure 13 at page page 44.
Yes.
Why the Annexure 13? I had been instructed to duly appear. I went there. I appeared in person, but for reasons best known to the concerned official, the concerned expert was not there. And as such, my lord, the verification had finally not been done. Being aggrieved, my lord, the petitioner preferred the application before the Central Administrative Tribunal.
After 8/2/2016.
My lord, my lord.
What
And
have you,
so for this,
what have you
origin-
written in your application? Let us see your OA.
my lord.
Which page?
My lord, just turn the page from 44. From page 45 is, my lord, the order of the Honorable.
We are asking
Central
you what
Administrative-
have you said in your OA, sir. We
My
are
lord,
not
that-
asking you what
I
has been
just went
recorded in the order.
My
We are
lord,
not
in the
asking you
OA,
what has been recorded in the
my
order. We are asking
lord,
you what have you said in the OA. Where is your
my-
OA? Show us.
Lordship, the OA is not part of the record. My lord, I'll bring.
Why? Why not? The rule does not require you to enclose the OA.
My lord, my lord.
Then
my
why
lord,
you have not filed it? If you are not interested, then what the court can do?
My lord, I pray for leave to
Nothing.
file the original.
Sorry, sir. This court is not granting such leave on a routine basis for those who don't comply with the rules while filing the writ petition.
My lord, the copy of the OA
Alright,
should
so
have
there
been.
is nothing on record. Then what is to be said? There is nothing.
My lord, kindly sees the order of the Honorable Tribunal, my lord.
Yes.
The inner page number of the order at page number 7, inner page number 7, paragraph 8. We are of the opinion that the concerned respondent authority were justified in calling the applicant for verification of his identity on
8/2/2016. The verification of the identity of any employee can be carried out at any stage of his career. However, since here the representation made from part of the railways was that the petitioner did not make himself present. My lord, my submission, my instruction is that the petitioner indeed was present in person, but the identification had not been carried out. And that is the reason for my grievance, and that is the reason this application has been preferred before your lordship, my lord. Here it has been recorded. However, since the applicant did not present himself for such verification on the said date, the respondent authority was justified in doubting his identity and in not allowing him to join his duty. The submission on part of the petitioner is that, my lord, indeed on the said date, the petitioner was present in person to get his identity verified in accordance with the rules. The concerned experts were not there, my lord. A person who was working at the office for long 8 years, his identity has been challenged.
You have never worked, sir. You have been all the time either ill or somewhere else.
My lord, I joined the service in 2006, my lord. Till 2013, I was in service.
You have joined on 1956. Yes.
2006, I was taken officially in 2006. And before that, I underwent 3 years of rigorous training. My lord, my only prayer is that I may be given a fair opportunity to present myself and get my identity verified. Because the petitioner is already on the verge of his career, my lord. He has already reached almost the retirement age.
There is the recent order of 29/7/2015.
It's 7/2015.
My lord, the recent order my lord will find at page number 38. My lord, the petitioner is here before your lordships to show his willingness to appear for whatsoever verification is desired from part of railways to prove his genuineness. The submission of the petitioner is that it is not a fact that the petitioner did not turn up on the day.
Been given ample opportunity. You're also not participated in the proceedings beyond filing of a reply to the charge memo. Nothing can be
My
done.
instruction, my lord, my instruction goes on to say that despite being given the opportunity on paper in real terms, when I made myself present,
This
the
reasoned order
examination had
was
not been conducted.
this reasoned order was passed pursuant to which order passed by the tribunal?
The order dated 9/6/2015, my lord.
Passed in
The order passed in OA number 350 oblique 00244 oblique 2016.
244 of 2016.
My lord.
Sorry, sir. Nothing can be done. Yes, take down.
My lord, the only opportunity I am playing for
No, sir.
is for an opportunity of making myself present in accordance with the
Ample
rules.
opportunity. You don't deserve any more opportunity. We are very
My lord,
clear in our
my lord,
opinion.
my instruction says he made himself present.
How many, sir?
By the
How
whim
many
of the
times?
officer.
How many times you will repeat that instruction? You must have said it 10 times by now. We have heard that. Don't repeat. Yes.
My lord.
Heard learned counsel for the petitioner as well as the learned counsel for the Union of India. The petitioner was appointed as a Group D Khalasi 19/5/2006 from on 5/6/2000, from 5/6/2013, he claims that he was ill and therefore could They're asking you, you have not even enclosed the order passed in 244.
My lord, I have, my lord. I have, after page 44, my lord, we'll see.
After
After
page,
page 40, after page 44, my lord. The order indeed is there.
all right, yes, 244, wherein the here in these proceedings. That's it. Cannot be in compliance of 244. Must be some other order. Which is the order in compliance of which the reasoned order was passed?
My lord,
Cannot be 244. You
lordship.
have given a wrong details.
Lordship, that number, Lordship, the previous one, number is the 00811.
811 of 2014.
2014.
It appears to be, but he is giving a wrong number there. For
No, no, that, Lordship will find it in the reverse, page 350081.
Yes.
Lordship, the arrangement is not done properly. P10.
My lord.
9th of
Lordship.
June 2015.
Lordship. 9/5/96/2015 order, my lord.
9.
6/2015 order, my lord.
2000.
Annexure P10 at page 35.
Yes.
The arrangement of
The
the
petitioner,
papers.
the petitioner in this.
19,
Your Lordship, Mr. Ujjwal Rai is appearing for the petitioner. His wife is seriously ill, Your Lordship. On that ground, I am paying only for not today.
Not good.
Grateful, Your Lordship.
20,
Lordship, same prayer, Your Lordship. Not today, only praying for not today.
Yes.
Grateful.
Grateful.
21,
21, I'm
My lord,
for the
item
petition.
21, my lord, I am for the petitioner, my lord. I am appearing online, my lord. Am I audible, my lord?
Yes, you are.
My lord, this is a matter, my lord, relates to recruitment in railway pursuant to notification of 0112. My lord, what happened? There is a series of litigations in respect of this notification, my lord. My lord, after the process was initiated, this petitioner, my lord, was called up to physical efficiency test and were not called for the remaining medical examination and every other thing. Several candidates, my lord, filed different way applications. My lord, the way applications were dismissed. My lord, thereafter, those way applications was challenged before the High Court. High Court division bench passed an order in the favor of the applicants, and that was ultimately challenged before the Supreme Court by the railways.
Please
This
let us
is
read the order. Let us read.
yes, my lord.
ঠিক করছে কি বলবে নেক্সট কি বলবে সেকেন্ডটাকে কন্টিনিউ কর why have you assailed the order?
Yes, my lord. Because an expert committee has already been formed, and on the same questions, my lord, and person have been given appointment. I am also challenging the same question. My lord, the need of another representation, again consideration, is a futile formality, my lord. Same questions, expert committee formed, they submitted their report, and on that basis, I have named one Pratap Bishwas has already been appointed by the railways. I have stated that.
Tribunal
Then
has,
what is the necessity of again going into all this?
the tribunal has already dealt with this. It has said that yes, it has to be considered in all respects. Why are
My
you
lord, it has to be considered. It has again relegated the matter to the railways for before the expert committee, but my grievance has been redressed. My lord, the expert committee kindly consider, my lord, the expert committee has opined that the following questions are incorrect and marks are to be awarded.
that
On
was
that basis, I
that
am
was
entitled to marks.
that
That
was
is what I am wanting.
that was opined prior to 24/6/2024.
20, that was prior to 24/6/2022. The
24/6/24, not
yes,
20.
my lord, 24 prior to 24.
But that is what you have approached the tribunal for this relief only.
My lord, I have approached the tribunal only for the relief that there is an expert committee. You give me the expert committee report and take necessary steps for appointment. What the tribunal has done, my lord, he has directed relegating me to the
What was
railways
your
once
prayer?
again.
Where is your prayer before the tribunal? What is
My
your
lord, yes, my lord, I have annexed, my lord.
68, my lord.
no? This is the prayer in the OA.
Yes, my lord.
What was your prayer in this the MA which you have filed?
My lord, way the
Where
original
is
order
that?
was passed, my lord,
Where is
in
the
the
MA prayer in the MA? Show the prayer. Don't
my
mix up.
lord. MA prayer, my lord, I am showing your lordship.
You look for it. We'll come back and we'll see.
My
Just
lord, only one indulgence, my lord. Only one indulgence. My lord, only one. My lord, because of medical emergency, I could not come at 2 p.m. My lord, I have a doctor's appointment. Can it be taken up Tuesday? If your lordship so desires, otherwise I will appear, my lord.
Tuesday.
That's why
Yes, prayed by petitioners council list on Tuesday.
grateful.
Item number 22.
Worship, I'm for the petitioner. The service has been completed, but Your Lordship, this is also similar to 9, 10, 11, Your Lordship. 1 week's accommodation may be given and all the matters may be taken up together, Your Lordship.
As per 1 week. Same as, give the same data, the same date as 9.
Obliged.
Item number 23.
23, I am appearing for the petitioner, my lord. I have served the copy to the respondents. I am filing a affidavit of service. My lord, respondent number 3 and 4, return it. My lord, case is, my lord, petitioner is a first wife and or respondent number 4 is a first wife who will get the service benefit of their deceased husband. My lord, I have come against the order of the learned of the Honorable Tribunal. My lord, the Honorable Tribunal passed an order that I am not going to the merits of the case and direct to the authority concerned to hear the matter within 3 months and pass a decision order. My lord, kindly see Annex P1.
Please read paragraph 5 of the order.
My lord.
Please read paragraph 5 of the order.
Paragraph 5(8) করতে বলছি। 5(8). 5, paragraph 5. Yes, sir. That your applicant petitioner beg to state that the one Biplab Moitra deceased married the petitioner.
Please read paragraph 5 of the order, impugned order, sir.
5 of the order 6.
The tribunal's order is dated 19/9/22.
Photo? 19/9/22. 5 of 29. Order. Input also. Yes, my lord. My lord, at hearing, learned counsel for the applicant would submit that he would be fairly satisfied if a direction is issued to the competent authority to consider and her representation at the time bound manner.
You have got what you wanted. What do you want? Why are you here?
My lord, kindly hear my respectful submission. My lord, who will get the service benefit of their deceased husband? Petitioner claiming as a first wife, and respondent number 4 is a claiming as a first wife. My lord, uh, kindly heard my respectful submission. My lord, kindly see annexure P1 page 35.
What you prayed before the tribunal has granted
My
you.
lord,
Why have you challenged the order?
I have to challenge my lord. The honorable tribunal passed an order, says I am not going to the merits.
No, not. Tribunal has not passed an order. You said that don't go into the merits, I will go to the authority. And it has said, yes, you go.
Going to my lord, the Lalne did not go to the merits of the case, my lord.
It has been decided by the authority.
My lord, judgment.
What happened? This order is of 22. You have filed a writ petition in 24. What happened in 2 years period? What you have
My
said
lord,
anything?
24, my lord, the petitioner moved and filed a suit for declaration of permanent injunction before the learned municipal, and the learned municipal was pleased, passed a judgment and decree against the petitioner. Then my lord, petitioner preferred an appeal before the learned district judge. District judge also observed several points and allowed a part against the order that the Department of Telecommunication preferred an appeal in the Honorable High Court. The Honorable High Court allowed the appeal. Then, my lord, I want to tribunal.
Then how can you go to tribunal when it has already been decided against you? Then what the
My lord,
tribunal can...
tribunal direct to the authority concerned to hear the matter and pass a decision order.
It is a futile order. If it has already been settled in a suit that you are not the first wife, then what the authority will decide?
My lord, kindly heard the submission, my lord. Then he became a first wife. He will get, but the respondent for did not appear before the London municipal, before the additional district judge, and also tribunal.
That has
Also
been decided
tribunal.
against you already. That has been decided against you. What can be done? Even this order is futile. What the authority will
My
consider
lord,
if in a suit already you have...
tribunal, my lord, tribunal passed an order. My lord, kindly see, tribunal passed an order that the in absence of the respondent number 4, passed the stop the pension and service benefit of both sides. My lord, kindly heard my respectful submission. Who is the first wife and first petitioner and or respondent number 4. My lord, respondent number 4 never appeared and she did not contest the case. My lord, kindly see page 35. My lord, petitioner married 31st January 1983. Kindly see, my lord. Page 35. Marriage documents, my lord. Kindly see marriage documents. My lord, kindly see. Page 35, annexure P1.
Where is the order passed in SA 523 of 95? SA 523 of 95. Where is the order?
My lord, can you heard my respectful submission, my lord? Who will get that? My lord, respondent number 4 never appeared before the learned court below. Never appeared. He did not contest before the learned court below, my lord. My lord, I married in 31st January 1983. My husband died on 17th December 1983. My lord, kindly see marriage documents of the petitioner. Kindly see. Annexure P1. My lord, kindly see page 43, annexure P2. My lord, kindly see page 43, annexure P2. Page 43. My lord, department supplied the adjusted photocopy without any other documents, only supplied. Only supplied, my lord. My lord, kindly see annexure P3 page 44, without logo of the Rajasthan government, my lord, issued a certificate. My lord, death is natural death or unnatural. If the natural death is doctor certificate is necessary. If the unnatural death is doctor certificate, there is no any other documents of burning heart. My lord, annexure P3, P4. Then, my lord, kindly see, after marriage, the petitioner husband, Biplab Kumar Moitra, my lord, submitted information to the authority concerned, and within 6 months, my lord, kindly see, and also requested to record my wife's name, Sipla, petitioner name in the service book. My lord, kindly see annexure P4, page 45. Page 45, my lord, kindly see, my lord, petitioner's husband's mother, my lord, made an affidavit. My lord, she lives at Jaipur, Rajasthan. He made an affidavit at Bombay. My lord, is it also suspectable? I have collected from the service book, my lord, of the concerned authority. Then, my lord, the petitioner used to live at Hazramur. She made an affidavit at Sirampur. Where Sirampur? There is no mention the district. Then, my lord, kindly see, she married, annexure people page 49, and she says, I have married 9th March 1991. My lord, within 3 years, the petitioner husband did not submit any documents to the department. My lord, petition, the respondent number 4 made an affidavit. My lord, kindly see the page 50, the learned advocate identified on 10th January 1983. My lord, after 1 year, my lord, affidavit on 10th January 84, my lord. After 1 year, my lord, this affidavit is maintainable. My lord, thereafter, my lord, kindly see the Department of Telecommunication Department Authority, my lord, paid the pension to the petitioner. My lord, kindly see, and a 51 page 19, page 51, annexure P7, my lord. Then, my lord, paid the pension. Then, my lord, the respondent number 4, my lord, submitted a statement to the department. My lord, item number 6, page, my lord, kindly see, 54, P8. 54, P8. My lord, item number 6, photocopy of attorney power. Of attorney power, who has given the attorney power? There is no any documents. My lord, kindly see. Thereafter, my lord, the petitioner filed a suit before the learned Munshi at Sialda. My lord, in spite of service of summons, the respondent did not appear and passed a judgment and decree against the petitioner. The petition prepared an appeal before the learned district judge. The learned that matter came up for additional learned district judge. The district judge observed in several points. But number 1 point was, my lord, the signature challenged the department signature of the signature of the petitioner husband. The learned affirmed, learned observed that signature is genuine. Thereafter, my lord, petitioner, the learned judge allowed the appeal in favor of the petitioner in part. Then, my lord, the Telecommunication Authority of Telecommunication preferred an appeal in the Honorable High Court. The Honorable, this matter came up for hearing before His Lordship, the Honorable Justice Vasudev Panigrai. His Lordship did not observe and dismissed allowed the appeal. Then, my lord, I have the respondent number 4 did not appear in the learned court below and also High Court. And also the petitioner filed an application before the Honorable Tribunal. The tribunal passed this order. And also the authority concerned, my lord, stop the pension and service benefit of both parties. Lordship kindly protect the petition.
Much less as regards service means so this is the final civil remains not authority to your second appeal, read the last sentence, page 8 of the order passed in the second appeal by the High Court. You are the plaintiff, you are claiming to be declared as the wife and you are claiming a direction of injunction be granted that the service benefit should be paid to you. Now see what the High Court has said in second appeal. Therefore, the plaintiff cannot claim any right, much less as regards service benefit through the deceased Biplav. So therefore, if this is a finding of the, then what is remains for the authority to decide? What the authority will decide now? It's a futile exercise. Tribunal should not have relegated it to the authority. It should have been dismissed. This is a question of authority considering. What is there for the authority?
Allow the in part, my lord, direct to the
Petitioner
author's concern.
claims to be
My lord, order passed. Item number 24.
Item number 20 appearing not today. This is Mr. Lokhi Kumar Gupta appearing in this matter is out of station.
Not today.
Let it remain in position, my lord. This competition.
Next.
25.
Yes, sir. I am for the petitioner, madam. Yes. I am for the petitioner, madam. Well, let the ABTV service, madam. Yes.
Entering to the merits of the matter, I want to submit one thing. That point has been decided by your lordship as well as the other division bench of our honorable court.
Yes.
That the learned single member, administrative member of the Central Administrative Tribunal cannot dispose of any matter. That point is also decided by your lordship following the judgment of Bachchan Pandit's matter. But my lord, that Bachchan Pandit's matter, the Central Administrative Tribunal himself, they have filed one review application. That matter was heard, my lord, in this week, and that matter, learned additional Solicitor General was also appeared, and that matter was fixed on 28th, my lord. So, my lord, your lordship can take up this matter after 28th, my lord.
And my submission is this is a case, maybe they different, my lord. My petitioner is the wife, actual wife of the deceased husband, my lord, who has died on
Have
23.
you heard what he was saying?
Yes.
Have you heard what he was
Yes,
saying?
my lord. There
The
is
issue
the two wife cases.
No, that's not the two wife case. Therefore, we are asking you, have you heard what
Yes,
he
my
is
lord.
saying? It is an order passed by the single member.
Of the tribunal.
Yes. They're not on merits. He is saying
Oh,
that
yes, no.
that issue is pending consideration.
No, that may be.
28. What is the number of that review?
On 28th, that matter was fixed before the Honorable Justice Division Bench of Justice Bossak's Division Bench. And my lord, I have also, my lord, requested the learned advocate on record of why they have preferred the CAT preferred the review application. My lord, this is very peculiar thing that tribunal himself preferred the review application, and they told that one matter went up to the Honorable Supreme Court on the same issue, and that matter stay has been granted by the Honorable Supreme Court, and that matter was also pending before the Honorable Supreme Court.
So there are two pendencies, one before and the one we have decided in that there is no review.
And your lordship also that point is decided in another matter.
Correct.
And following the judgment of the Bachchan Pandit's case.
Yes.
And that review application in connection with the Bachchan Pandit's matter, that is pending, my lord, that is fixed on 28th.
You have the detail of the case?
No, my lord, detail of the case I have, but I can.
Can you give it in a short time?
Just now, my lord, that I cannot, my
That I have already been heard in the cap.
Then you come with the number, not today.
My lord, then my lord, kindly fixed it on 28th.
No, we'll record why we are adjourning. Not today means it will come on Monday. You give the date, the case number. So Monday is what, 20? Monday is 27th. Monday is already 27th.
My lord, it is better for us if your lordship take it after 28th, my lord.
No, after 28th.
As prayed by the, jointly prayed by the parties. Matter to come out.
Grateful, man. Single bench correct.
Number 26.
My lord, that item 25, that advocate on records of that that matter is giving the number.
Yes. Single bench pass করতে পারে কিনা?
Review application number 376. Please.
Review application number? Arbiter. 376. Sure. 376. So, 6 February. Yes, but may I be please? My lord, item number 17, my lord, 2 days with the same, my lord, single bench has passed, my lord. That may be also kept in 6, my lord. If your lordship be please.
Your Lordship, I am appearing for the petitioner. I am the advocate on record in this matter, but the arguing counsel is from Patna, Your Lordship. So my prayer before Your Lordship, keep the matter fixed any day as per Your Lordship convenience, so that he can come from Patna, Your Lordship.
My lord, in this matter, the learned Deputy Solicitor General is appearing, my lord. I would only beseech your lordship, my lord, first week of February, any day, my lord, if your lordship can fix this matter.
Any day as per Your Lordship, fix the matter.
Yes, you give a date. My lord, 5th of February. Deep brigade.
Much obliged, Your Lordship.
Deep brigade.
Item number 27. Adjournment house, Senior Supreme Court gেছে Bharat Bhushan.
Item number 27.
Your Lordship, I am appearing for the petitioner on behalf of my learned senior, Your Lordship. He is in Supreme Court. I am praying to Your Lordship to adjourn the matter till Tuesday, Your Lordship. Keep the matter any day after.
I am appearing for respondent.
Wednesday. 29th, Your Lordship. He will return on 28th. Please keep. I am praying to 29th. No, till Tuesday he is out of station, Your Lordship.
Item number 28.
My lord, item number 28 and 29, my lord, I am praying for 1 week adjournment, my lord. Mr. Ajay Chaubey is appearing in this matter, my lord, for the petitioner. He had gone for Kumbh, my lord. Only 1 week adjournment.
Lord, I am appearing for the respondent employees. Lord, virtually, Lord, nothing is Lord, in the writ petition, because Lord, the order passed by the tribunal following the Lord, order passed by the division bench of Madras, and thereafter Lord,
দেখে নাও, না কোনো অসুবিধা 28 and 29.
Item number 29.
My lord, same, my lord, 28 and 29.
Lord, any date, Lord, 30th or Lord, 31st, Lord, I have some Lord, difficulties. Lord, any date, Lord, not Friday, Lord, 31st, 30th or 29th or any.
February
30th. Yes.
30.
28 and 29.
30.
Item number 30.
কি করবে?
Appearing for not today on behalf of Rajesh Shah, appearing for the petitioner, my lord.
কোন title? I am appearing for the petitioner, my lord. Who is he?
Mr. Rajesh is also appearing on behalf of petitioner.
He is my junior. Do you mind? Please sit down.
Well, this is a application is against challenging the order of the tribunal, which has directed appointment on compassionate ground with effect from 2003, 29/4/2003. Order is being passed, my lord, on 27 July 2024, my lord. The fact is in 2003 he applied. His name was recommended. Thereafter, the panel was recast. He was then not given. Well, that I could not find out from the. It was recast, my lord. Subsequently, he was asked and he kept on. He did not challenge that order. He kept on applying repeatedly. More than 5 times he applied. Then, my lord, in 2020, possibly 22, he has 20, 23 he has filed the writ petition. This application before the Central Administrative Tribunal. Even the Central Administrative Tribunal Act, my lord, section 21, there is a limitation that you have to come within 21. Now, my lord, if the original rejection is the cause of action, then my lord, it is barred by limitation. So can you look at margin? Will you move from here or not? No, my lord, if the original act of recasting the panel was illegal, my lord. My lord, he should.
According to you, he is entitled to this appointment with effect from which date?
My lord, that was never challenged. He's not now. He is not does not have any right, my lord. At present, my lord, when filing he does not have any right because compassionate appointment is not a vested right, because at that time he did not challenge. He went on making subsequent applications. My lord, as per the rules, 5.
Your case that there are 5 rejections. It is
Yes,
your
yes,
case
yes,
that
yes,
there are
yes.
5 rejections. So
No.
therefore, don't say that 2003 was the last. You have
No, no.
considered after 2003 also.
No, no, my lord, it is not a continuing cause of action. They will have, because
That is a different issue. What we are trying to understand is
my lord, what I am saying is that had he been aggrieved by the original order,
that
he
we have
should have. He
understood.
should have.
We have
My
understood.
lord, now subsequently he has been applying time and again, and it has been rejected.
All 5 times.
All 5 times possibly, my lord.
Why?
Well, because some of the cases were not because there was no vacancy.
Please come clean with the facts. Why all 5 occasions it has been rejected?
My lord.
Let us know the entire thing.
My lord.
We have understood what you are trying to say, but we want to know his father first he suffered a disability, later he died. You have been considering for 21 years. Where is the compassion in the process? That is what we are trying to understand. We can understand that if the vacancies are limited 5%, there are more people in line who are all similarly situated, whose claim have occurred senior, but there's nothing, we can't find anything.
My lord,
So
from
we are
at
trying
least
to see, because we find that the tribunal has recorded that 5 times it has been rejected. Why? Once you say it was closed, then you again reopen, then you say 5 times rejected. So such a person who is in need of the benefit of your policy of compassion.
well, unfortunately, the Honorable Supreme Court thinks otherwise.
No, it does not. It's
Well,
once you have framed a policy,
no,
you must
Supreme
go
Court,
by it.
no,
There's no question of vested right.
no.
He is entitled to treatment under the
My
policy.
lord, the Honorable Supreme Court, I've got the judgments, my lord, has said that compassionate appointment is to be given immediately after the.
Correct. So that is
If it
against
is,
you.
if it is, no, my lord, the judgment which says when you have come,
He has not. He has been knocking at your door since his father was still alive. What are you doing since 21 years? That is what we want to understand. You make a policy, you say it has to be done immediately, and you say 5 times rejected over a period of 20 years. What are you doing? That is why we want to see.
With that, I will come back, my lord, with further
with these
instruction.
facts.
What were the reasons for?
You must show to the court that you have, as per the policy, accorded due consideration to him. And after due consideration, all the 5 rejections are there. If you are able to show that, then of course, it's a different matter.
But 2003, I am selected.
That we have seen. That we have seen. You are selected, not offered. The vacancy got recast. You did not challenge. These are facts. We have seen both sides.
Well,
but we want to be satisfied that you have done what was required to be done, because it's an issue to be guided by the policy of compassion.
Well,
so just come with it. Can you show the 5? Is it on record? The 5 rejections? Or do you need to file a supplement?
No, my lord, I'll have to go through, my lord. Rejection
Because the dates are mentioned in the order, therefore we are asking you.
Yes, my lord.
In one paragraph, we have found that the dates are mentioned. Paragraph 6. Then 7, then 8.
There are file notes attached, my lord.
You may file a small supplementary affidavit. Just place the facts on record.
If at all, my lord, because I had not gone through these facts
Yes.
while
That is there in the order. Just see.
Possibly it is also in the affidavit, in the petition.
Maybe.
It is also.
Should we adjourn it or today?
Yes, my lord.
After some arguments to stop, the court has put a query.
29th money, Wednesday.
Item number 31.
My lord, I'm for the petitioner, my lord. This relate to the compassionate apartment, my lord, and in violation of the High Court's order given.
What happened? Your claim has been rejected.
My lord, they have last occasion they had they wanted to submit the evident objection reply, but they are not submitted reply. The legal option.
Yes. Yes, where is your affidavit?
For extension to file our reply, Lordship, it's a change brief. We are duly assigned to this matter, Lordship. May I pray for an extension to file the reply, Lordship?
You are Deepika Sarkar.
Deepika Sarkar.
Why you are saying change brief? You were here on the last day also.
I beg your pardon, Lordship.
What is this? Why you make wrong submissions to the court
Lordship, I beg your
for
pardon.
an adjournment? This is not expected from any counsel.
Lordship, actually,
At least you would have gone through the order before making a submission. You have prayed for time to file affidavit, and now you are saying changed brief.
I beg your pardon, Lordship. I pray
Very
for extension.
unfortunate. This you should not do.
Beg your pardon, Lordship.
Time for filing affidavit in opposition is extended by week from date by way of last indulgence.
Thank you.
Malat, I am appealing for the petitioner. Malat, here I am challenging the order passed by the State Administrative Tribunal, that is Malat, this is the recruitment process in the year Malat 2011. Advertisement has been published. That is Malat, the order that is page 39 onwards. Page 39 onwards, and operating portion is page 41. Matlab page 40 as per.
We set aside the order, what will you get?
Matlab, though this is recruitment process in the year 2011.
What will you get? We are asking you. You applied as a general category.
No, my lord. This is, my lord, their submission, and though no document has been produced to me, only, my lord, that was their submission that they produced before the tribunal.
Madam, you are not arguing in a review jurisdiction. You are arguing in an writ. The tribunal asked them to come out with the details. They say, what is the question of PH category? He is or she is a applicant of general category. You say, well, even if I am a general category, if that infirmity is there in the advertisement, you set it aside. The tribunal says, where is the question? You are not a person aggrieved. An academic issue is being raised by you. Nobody who is aggrieved has come forward. It has rejected. If we set aside, what will you get? You are a general category candidate. You will get nothing.
I am disabled person, and, my lord,
No, you are
that
not.
was, my lord, that I annexed, my lord, that document, and that was
You
also.
may be, but you have not applied as a handicapped person.
My lord,
You have appeared in the process. You have gone and got yourself under the physical verification also. Only when you have failed in the entire process, then you have come
my lord,
around.
that is in the application form, my lord, I applied as a disabled person with so
here.
Submitted, and I filed RTI application within time. They did not reply, choose not to reply. Nothing has been informed to me, and they only their mere of submission that I applied for general category. My lord, I applied as a disabled person, and, my lord, that was also examined before the concerned authority, and within time I filed the application, representation made, and OA application has been filed. And they did not never produce any panel. What is my position? And, my lord, the application which I filed, my lord, I claim that I filed as a disabled person.
That is not
And
the,
there is no
as per the
opportunity given.
records, that as per the records,
Malad, no
it is your case that you applied as
Malad,
general
let them
category.
produce the case record, or my lord, by way of affidavit, my lord, though for that person purpose, my lord,
If there is a factual, that factual error is there and it has wrongly been recorded, your case has wrongly been recorded, then that is not a issue which you
my
can
lord,
take
let
up
them
here. You
produce
are required to
my
contribute.
application form, my lord, I applied for physically handicapped person. They said that I am general category. Let them produce, my lord, what they relied before the tribunal. And no opportunity has been given to deny their submission. Only mere submission, my lord, tribunal dismiss my application. I also annex those documents in my application.
And the point, the process concluded in 2012.
Yes.
When all the posts have been picked up.
My lord, immediately after that,
Understood. That is why we are.
immediately after that, my lord, I filed. My lord, the first application made, my lord, in the year 2012 itself.
Handicapped person. What is your prayer in the OA?
Yes, my lord. That.
Why nobody annexes the
My
OA?
lord, OA application.
Nobody is complying with the rules for filing. Nobody is annexing the
My
OA.
lord, that is.
What is this? You don't want the
Yes,
court
yes,
to
my
say
lord,
anything.
that I have to, my lord, annexed in the application. My lord, this is true. My lord,
It is there.
No, my lord. This is my change brief, my lord, by way of supplementary
No,
evidence.
now
My lord,
nothing,
this
no
is my lord file, if your lordship in earlier occasion dismissed for default, my lord, after my lord getting.
Why don't you
after-
comply
my
with
lord,
the
this
rules
is
for
true,
file?
my lord, I know, my lord, annexing the OA application, that
Nobody is
have to,
annexing.
my lord, yes.
Every day we are saying this, don't
My
file
lord,
like
this,
this.
another advocate filed this application, after that changed brief, my lord, I restored before your lordship the application. But OA application, my lord, I have to annex by way of supplementary affidavit.
No, now no supplementary. Now we'll proceed as it is.
Yes, yes. Application copy down. Huh?
Huh? It is here in hmm. E7 supplementary.
My lord, the Equal Opportunity Protection of Right and Full Participation Act 1995, my lord, as per the clause, my lord, 3% reservation in any public employment, my lord, there was a specific guideline.
They applied as a general condition.
Equal Opportunity Protection.
Mine is clear. One copy is clear.
ওই নাম্বারটা হচ্ছে 1234 1234 154
Very good. Just now. Yes. Supplementary affidavit. This is this. Paralysis. He is the orthopedic surgeon. Hmm. Annexure P7 to your supplementary affidavit. Come to annexure P7, your supplementary affidavit. Very unique certificate. What does it say at clause 6? See?
My lord, incomplete copy has been given to me, my lord, by my client, my lord.
So
Now
not
I
only you have
one-
given us incomplete,
My
you
lord,
don't even.
my lord, the advocate, earlier advocate, my lord, did not produce.
Please
my lord.
ask them to show you. You see P7. We'll take it up, not today. You go through it.
Yes, yes.
P7 of the supplementary affidavit.
That is not with me.
Go through it. Yes, filed it
Don't need to supplement.
as paid by learned counsel for the petitioner. As adjourned. Bingo. 33 will be called.
31, 31.
Item number 33.
33.
33. And on the last occasion, my lord, I mentioned it, this matter appeared before your lordship. There are 3 connected applications, and your lordship direction was let all the 3 matters be placed.
Yes.
Only one has come again. Yes. These are the other 2 matters. I have given earlier the requisition also. Well, another one is 256, another is 258.
We have passed an order.
No, my lord, at the time of rising of the court, my lord, your lordship directed that. No order has passed. 3 matters are together. All the 3 matters come together.
They are all for the same relief.
Yes.
Other matters.
সত্যি কথাটা বল না যে আমাদের বিপ আমরা পাচ্ছি না এই যে বলছিল
No, the other 2 matters, if my lord can supply the copy, then he can appear.
To give him. That's why we are asking him. He must be, if he appears in all the 3 matters, that will be better.
Yes.
Therefore, we are asking him.
Yes.
You are.
Because other 2 matters, my lord friend is mentioning, if he supplies the copy, then I can appear.
It's not absolutely impossible. So much. From Supreme Court right up to here. Find out the brief file.
No, other 2 matters.
Your lordship will kindly not tax the poor litigants in this fashion. All these people are retired employees.
No, even if they are serving, we don't do it. We leave it
In
to
that
the
case, the
council.
court will do it.
We leave it to the council. If they want, they serve. Otherwise, they will have to arrange. You cannot be required to serve twice or thrice. We are very clear.
But at the same time, the court will not impose, my lord, that charge upon the.
That is
It's
what
not
we
their
are
fault, we
saying.
did.
You cannot be required to
We
supply
served it.
twice or
My
thrice.
lord, we served it.
Correct.
We did, sir.
That's what we are saying.
Yes.
That is what we are saying.
This is the 2014 matter. That's
Whatever it is, you have the brief.
no. My lord, only difficulty is 2014. Look, several panels
First, who is appearing in those two matters? Whether you will be appearing or
some other person.
or somebody, we don't know.
And
Are you appearing in all the three cases?
No, since this matter is appearing in the list, I am appearing.
It's happening in this in the judicial system.
Are you appearing in all the three cases?
Yes, number 20.
So you know who is appearing in the other two cases.
Pardon me.
Who is the learned counsel appearing in the other two cases? Do you know?
Or 256.
256 and 258. 258. 2014.
Huh? Yes. Yes. Like that. He appeared courage.
256.
Any money, government money, na? It is all right. Do it. As you like.
So he is appearing.
Yes.
In all the three matters.
Yes.
Then he will either he will get from the government or he will get from you. Then he knows how he will get the brief.
And he asks again, as if it is an arm. Well, these are the two amendments.
Is submitted by the senior counsel.
Mid fools. I'm deeply worried.
Yeah,
10th of February. All the matters together.
Item number 34.
কত টাকা?
Item number 35.
Lordship, I am for the respondent praying for not today.
Yes,
My lord, praying for not today.
not today.
Grateful, Lordship.
Item number 36. 37.
My lord, kindly make it not this week. 37, my lord.
Why?
My lord, council in this matter,
Not today.
my lord.
Thirty-eight.
I am praying not to do my lord, Mr. Nata. No emotion within the
39.
Lord, I am for the petitioner in this matter. I am led by Mr. Vikas Ranjan Bhattacharya, my lord. I am pleased.
Yes, give the file.
কতবার copy supply দেব? Now my learned friends telling me to supply the copy of the petition.
All right, let us see.
Own cost lordship, and he give me one copy.
The voluminous paper, na lamba petition I have. All right, I shall give you again. Again, I shall supply you. So, my lord,
We are not going to direct.
okay.
He will not direct. If
Okay,
they
my
want
lord.
to supply, they will supply, or you find your brief. Why should they be required to supply again? We don't know, but somebody must have been appearing. It's a matter of 20.
All right, my lord, I shall supply him.
একটা চিঠি দাও না করে দেবো।
When should we keep it?
Yes, madam. Next week?
As jointly prayed,
সোমবার দিন দিয়ে দেবো ফোন, হ্যাঁ।
matter is adjourned to
আর পরে কতবার?
30.
তাহলে এখনই দিয়ে দেবো পিটিশন।
Item number 40. 41. 42.
41.
41.
40, I am appearing for the respondent, your lordship. My senior has gone Supreme Court. I am praying to your lordship, keep the matter on Wednesday.
Not today, yes.
41.
I am for the respondent.
41 you are for respondent. Lips will collapse. Yes, call. Nobody is there.
42. 43.
42, my lord.
Yes.
My lord, I'm representing the petitioners. I'm on behalf of Advocate Shruti Shamanto. He is out of station and won't be here for this week. So would you please accommodate this matter 40 to 43 and a certain analogous matters which are listed 56 and from 61 onwards
No,
to
no,
Monday?
only the matter which is being called.
42 and 43 for now.
Not today. Yes.
Okay. Grateful.
44.
You are for?
Respondent, your lordship. Ms. Amrita Pandey is appearing for respondents.
Next. Call.
45.
From 45 to 51, I beg to appear for the petitioner. My lord, if my lord recalls, these are all the land loser matters, my lord. My lord, one of the matter appeared before your lordship, where lordship called for judgments, and I supplied your lordship, and that is item number 97. In that, my lord wanted to go through the orders. And firstly, whether contempt under contempt jurisdiction, whether here it will appeal would lie or not. My lord, I have given my lord the larger bench judgment, and relating the similar matters, Justice Tendon's order, my lord, a coordinate bench of Justice Tendon, Justice Venumani, and Justice Topobrata Chakraborty, on the self-same cause of action, several orders have been passed, my lord, in respect of the land loser matters, my lord.
So it should come with 97 then.
My lord, 97 is appearing.
Let all be taken together.
Just a minute.
That
Just
is
a
better
minute.
if you have supplied all the orders in 97.
Yes, my lord.
Let it come with 97.
But my lord, in respect of item number 45, 46, and 47, it's a bit different, because in respect of 45 and 47, my lord, these advocate for the railways appeared and said that there is a dispute in the land of the petitioner and they will be filing opposition to that regard. My lord, this is an order of October 2024. There was a certain
for the railway.
My lord, well, Mr. Nondi was appearing.
Let it be not today. We'll see. Yes, 45 not today. Please intimate him.
My lord, I will intimate, but he was sitting outside only, my lord. I saw him.
46.
But 45 to 51.
You are appearing in all.
All the matters. And 96 to 101, my lord.
When we get there. All these
52.
matters not today.
Item number 52.
My lord, instead of not today, my lord can fix on Tuesday, my lord.
Why?
My lord, Monday I have a fixed matter in the tribunal.
See, it will be much below on the list. All these matters have been adjourned. We'll see.
My lord.
Three.
My lord, I am for the petitioner, my lord. My lord,
yes. Start.
My lord, kindly give a short passover, my lord.
Why?
My lord,
the file give. IA is pending. Three.
Well, kindly grant me a short passover, my lord. Well, a brief has not come, my lord. Kindly a short pass.
Your Lordship, this would take a detailed hearing if Your Lordship could take it up on Monday. Item 50.
Petition copy আছে? হ্যাঁ? টাইম দিচ্ছেন না। Petition copy.
Your Lordship, may I briefly state the facts?
Is the order passed in the LPA? LPA 31 of 2014. Okay. Can you read page 110?
Yes, my lord. We are of the view that right course of read court was to allow read court to allow the appellants to comply with the order dated 15 November 2024 2014, consider respondent read petitioner's claim for release of unpaid salary and pass consideration order.
We asked you, can you read? So you can read.
His face is middle.
Please be kind to us also.
I'm sorry, but I apologize. I apologize. Type copy, I will file Monday.
Give it.
Yes, I'm sorry. It is my mistake.
Why not give the entire order?
Yes, entire order. Entire order, Tuesday, Thursday minute possible. Thursday.
Any day.
Thursday minute, Thursday.
Since much hinges on the order passed by the division bench, the LPA.
Sorry, minute. Yes. Just a minute.
What is the
Entire order, my lord, entire order. It starts from, my lord, 105.
LPA number?
My lord, number 31. Number?
31. What is the LPA number?
NPA number 30. That is, my lord,
192.
192 of LPA number 2014, IA number 302 2014.
No, no,
LPA number?
192.
192 of 2014 LPA and IA number 302 stroke slash 2014.
Since much
Item number 54. Fifty-five. 54. We are for the.
Petition amendment.
But in 2006, two persons filed original applications before the tribunal. But during the pendency of the applications, the applicant number
for what?
for certain reliefs under the notification issued by the state government. Because they claim that we are governed by the common cause of action. And they joined under the rules that every application filed under section 19 has to be verified by a person competent to do so. Namely, then Malad, applicant number 1 verified it.
One person has unfortunately passed away.
Passed away in 2011.
And he is the person who swore the affidavit.
Affidavit.
So now you are saying it is incompetent.
But my lord wanted to see the notification issued by the central government so far verification is concerned. My lord, I have got the copy of the gazette notification issued by the central government.
He's not come to court today, so he has.
Just let us see what he is giving. He will share with you. At least you can come prepared on this.
State government application verification.
Kindly see rule 4 verification, how is to be made. Your lordship wanted to see on the last occasion this rule, whether there is any rule or not. Page 17, kindly see application under
We had
section.
gone through the provisions of the Administrative Tribunal Act the other day.
Yes.
Where the central government had framed the rules. But here there was no rules.
No, here there is a rule issued by the framed by the central government.
By the central government, yes.
By the central government. This is the rule framed by the central government.
Yes, yes.
Kindly see in exercise of powers conferred by subsection 1, read with clause D and E and F of section 2 of section 35 of the Administrative Tribunal Act, the central government hereby following rules. These rules may be called West Bengal Administrative Tribunal Procedure Rules 1994.
This is
have you lordship got it?
framed
This
by central government.
framed by the central government applicable to the state of West Bengal.
State of
And kindly see rule 2, sub-rule 5. Notwithstanding anything contained in sub-rule 1 and 3, the tribunal may permit more than one person to join together and file a single application if it is satisfied having regard to the cause of action and the nature of the relief provided for that they have a common interest in the matter. That means there must be a common cause of action, then they can file a joint application. I have got copy of the original notification issued by the central government, but this Hindi, that's why not I've handed over to you. What item is given you? They on the after the death of the person concerned, about more than 12 years, they filed an application for substitution and application for setting aside amendment. But that application was withdrawn. That means there is no application. But in spite of that, learned tribunal granted benefit to the person concerned, legal representatives or family members of the applicant number 1, who was dead in 2011.
That is one aspect of the matter.
Yes.
That is part of the matter.
Then, my lord, further that the tribunal has got jurisdiction to take up the matter when the application has been abated. And my lord, on the last occasion, lordship, whether the civil procedure code would be applicable or not.
Yes.
Mr. Director, my lord Justice NP Singh, when his lordship chairman in Supreme Court, when I decided that in a writ proceeding,
Not writ proceeding. This is proceeding under the Administrative Tribunals Act.
yes.
This is we are trying to ascertain whether it will apply to a proceeding under the Administrative Tribunals Act.
Yes.
When the Administrative Tribunal Act in specific terms says it will not.
Civil procedure.
CPC कोথায় বলা কি বলতো?
Applicability.
আমার পুরোনো বইটা কোথায়? আমার বইটা না হয়েছে অন্য বই নিয়ে এসেছে। আমার বইটা দিতে বলছে।
এই পুরোনো বইটা আছে জিজ্ঞেস করতে
আমার বইটা তো
জানেনি না রুল 18টা দেখুন তো রুল 18টা
রুল 18 এটাতে
Rule 18 पे बताया dismiss for defaulted. হ্যাঁ? না, দেখি দেখি তখন আমাকে একটু বইটা দিন, বইটা বইটা। সেটা রুলস ব্যাপার। সিপিসি অ্যাপ্লাই করবে না বলেছে। দেখ
Section 22.
Yes. Section 22, Lordship, can you see the language?
Yes. Not bound by the procedure laid down in the civil procedure code.
Code.
Specific terms.
Yes. A tribunal shall not be bound by the procedure laid down in the Civil Procedure Code 1908, but shall be guided by the principle of association and subject to other provisions of this act. And any rules made by the central government and tribunal shall have the power to regulate its own procedure,
Correct.
including fixture of the party.
So no application of civil procedure.
This is the rule. This is the rule framed by the central government.
This does not say, what does it say about substitution? What does it say about substitution?
এই যে রুলসে রুলসে
Rule substitution.
ওই যে 18
Kindly see.
There are two aspects. One, if there is no substitution, whether the order will sustain insofar as that particular applicant is concerned. The other is because the deceased has sworn the affidavit.
Yes.
Whether you say that the judgment will not be maintainable in respect of anyone.
But if cause of action is the same,
Yes.
the first test is whether the cause of action is the same. Then, the person concerned swears affirm the affidavit or verified the petition. Then what the entire thing goes.
Once it has been allowed without your objection to be that they can all join cause of action.
Yes.
That argument, whether it is open to you now.
No, I'm not saying that.
Yes.
Their pleading was that because of the common cause of action, we are filing joint application.
Correct.
Verified by a person.
Yes.
Now, verification, verified persons died.
That is what we are saying. That the other aspect is that if the person who has died, he had verified, then you are saying it cannot be maintainable for anyone now.
First question. If my lord holds against me,
Yes.
that no, if the person is no more in the world, then this application will remain for the remaining persons.
Yes.
I am taking for the argument that this view is taken by the court.
Then you say that if for him it is
then
certainly abated.
Yes, the entire thing abate, or the part of cause of action will be abate. Because cause of action cannot be segregated. Cause of action was the same. Non-payment of certain financial benefit according to the applicant. If it is by death of a person segregated, then whether that application could be entertained by the tribunal. Order 22, kindly see for a moment.
No, that CPC we are order 22, order 23, rule 2.
Yeah. Order 22, rule 2.
22 rule 2 or 23 rule 2?
No. Order 22, rule 2 of CPC. If the application for substitution. Civil Procedure Code, most of the is a procedural law, but it became a substantive law when deals with the rights of a person. Central government rules to the rules substitution ta kodai korbe.
Huh.
39. Yeah, 39.
39.
Hmm?
Is it?
39.
No, no, 39. Substitution.
And when I kindly see the Central Administrative Tribunal Procedure Rules 1987, Rule 18, substitution of legal representatives. In case of a death of a party during the pendency of the proceedings before the tribunal,
90 days we have seen.
no, the Rule 18,
Yes, 90 days we have seen.
yes. And but that application has been withdrawn. I do not know what reason they have withdrawn the application. Whatever may be there. And the tribunal allowed that application to withdraw the
Who is for the respondent?
What?
Who is for the respondent?
He is appearing for the respondent. He's not come to court today. I am not in this matter.
Yes, you just mentioned that he has asked you to.
And this maxim has been considered by the Supreme Court. States rules 28,
10.
the rule Roman 10. Of the state rules.
Rule 28.
Rule 28, sub rule Roman 10.
Ten, 11,
10, 11,
and 12.
and 12. Accepted the application.
The registrar's power.
Registrar's power.
এটা আমাদের ওয়েস্ট বেঙ্গল রুলসে রয়েছে কিন্তু সেন্ট্রালে নয় ওয়েস্ট বেঙ্গল রুলসে রয়েছে
না কিন্তু লিমিটেশনটা বলুন
হ্যাঁ বলেছে
order of amendment. But the same language of order 22 has been quoted here.
অ্যামেন্ডমেন্টের কথা যেই আসছে তার মানে লিমিটেশন আছে
As soon as the word amendment has been incorporated there, that means one of the substitution has been made
within a period within a specific period of 90 days.
Within a period of 90 days. But that chapter is closed because he filed an application for setting aside amendment and application for substitution, but withdraw the application. Two persons were there. Two persons. One died, but the persons who have been given directive, we have been implicated them, also party here. Common way, common way. এই ম্যাক্সিমটা দেখতো প্যারাগ্রাফ 10টা দেখ প্যারাগ্রাফ 10টা দেখ এর বার কত অর্ডার 22 বার কত Yes. Because
Your Lordship.
it published any other books. I have when I much difficulty. One of my junior in the practicing the Supreme Court, he sent from the central government and said because the central government notification sometimes in 1994 there was no computer etc. That's sent to me by mail and I've downloaded from there. No, it is published by the central government. I got a published by the central government, Gazette of India. Yes, State Tribunal. No, it has been published by the Government of India in the Gazette of India publication.
Publisher ধরে তো আপনি করতে পারেন।
Watch a books.
Like publisher, Venus publisher.
Yes, we have got. Yes, sir. Yes, sir.
Yes.
With great respect to the political executives of the department present government, there should be all the rules. Just I've seen in the Kerala High Court and other Bombay High Courts that as soon as the Gazette is published, all copies forwarded to the High Court and the Advocate General Office must be there. And when yeah. Yes. And there is a separate department. All gazetted. But here they had the office of the learned advocate general is too much small space. Only one room.
So many space. Union has only one room. Only LC room. Others, DSCs don't even.
There was a litigation in this honorable court. Who is the owner of this building? When it is found ultimately after the owner state is the owner and High Court is the occupier of this land.
Now the entire rules and regulations have been published by the state government. Indicate in something like that, Mr.
You can actually have a website wherein all the rules and everything can be there.
Careful.
Input has it all.
Item number 55.
55. My lord, in this matter, my lord, an advertisement on the month of my lord February, 8 to 14 February 1997 was issued by the Railway Recruitment Board. My lord, Employment Exchange News, my lord, it was published. My lord, we applied for my lord inquiry cum reservation clerk and trainee commercial clerk. My lord, all on a sudden, we came across an incident, my lord, which says, my lord, the entire selection, my lord, stood cancelled, which I pleaded, my lord, in paragraph 4.
February 97.
97.
Which
8
two
February, Millard, post of Millard, the inquiry cum reservation clerk and trainee commercial clerk.
Your Lordship, before my learned senior proceeds, we will answer on Monday, Your Lordship. He may conclude his argument today and we may reply on Monday.
Yes.
Now, Millard, we received call letters from the Railway Recruitment Board to appear before them. We appeared. All on a sudden, Millard, we came to know, Millard, that the entire selection process stood cancelled. We, Millard, the decision of cancellation, Millard, that was questioned before the Honorable Tribunal, the Central Administrative Tribunal. Now, Millard, the Honorable Tribunal, Millard, ultimately did pass an interim order directing the respondent not to publish the result of the second examination. They decided, they contemplated to hold a second examination, phrase examination. Millard, the interim order was passed to that effect. Millard, the learned tribunal.
After washing off your process, another process was
Another
initiated
process
for
to
the same post.
For the same post. Now, so Millard, the tribunal gave liberty, Millard, to the applicants to appear before them, the second
The
examination.
second one you may participate.
You may participate. And Millard, ultimately, Millard, the 4 applications, there were 4 applications, Millard. We questioned such order, Millard. We came before your Lordship's court. Millard, ultimately, on 29th January 2014, Millard, this honorable court was pleased to dispose of the petitions directing the Railway Authority to engage the applicants in the post of inquiry cum reservation clerk. Millard, may I take my lord's kind attention to page 25 of your Lordship's brief.
'53 of 2008.
Yes. Judgment. High Court. 29 January 2014. My lord has got it. আমরা কোনটাই ছিলাম? হ্যাঁ, আমরা কোনটাই ছিলাম? 27. Our application is 31. এটার উপর ইডেট করে পাস হচ্ছে।
Yes, then what happened?
Yes. Now, Millard, accordingly, Millard, after this, Millard, page 31, Millard, kindly sees. This relates to our matters. This is, Millard, we appeared. And Millard, same benefit was conferred upon us, Millard.
So you were not a party to this order.
I was not a party. But following that order, Millard, I derived a similar matter. Millard, this is a different petition in respect of the same selection process. And the benefit was conferred upon my clients. Millard, this is the order 31.
You had moved the
This was
tribunal before those persons. You had moved the tribunal 1 year before those persons.
But ultimately, since the Diden Millard, the learned senior advocate Millard, Mr. Moitro Millard appeared, Millard, the ultimately Millard, whatever is the fact, Millard,
Same
same.
On the same date also.
Yes, same day. Yes, analogously heard. Analogously heard, Millard, this was done. Now, Millard, what happened?
You were also required to be, your marks were to be examined and then appear before
Right.
the interview.
And everything was completed. I joined Millard. And Millard, what happened? Millard, 10th July 2017. Millard,
When did you join?
10 July 2017, page 72, Millard. Millard, dispose of 2 point. 10th July 2017, page 72. It's 33. Sorry, appointment letter Millard, 27th, এটা কত হচ্ছে? Sorry, 27th March 2014 Millard appointment letter, page 33. This is Millard, the provisional appointment as per trainee Millard scale of such and such. This is the grant. Now, Millard, after this Millard, 10/7
in terms of the old recruitment.
Now, Millard, I clarify this, Millard. The recruitment that was made, Millard, that was guided by Millard recruitment rules of 1997, and Millard, the service of the writ petitioners, Millard, were governed by the then prevalent rules of the railway as well as the railway service pension rules 1993. Millard, if they had been given appointment after completion of the selection process initiated at the advertisement, which was way back in 8 February 2097, Millard, that was our claim. Be that as it may, Millard, National Pension Scheme, Millard, intervened in this matter. And Millard, they said, no, you are covered under the National Pension Scheme. Since your appointment was provisionally made on 27 March 2014, you are not entitled to do so. Millard, during the pendency of this continuous litigation, Millard, the government, Millard, had decided to go back to the old pension scheme. So today, I cannot have possibly any grievance with regard to the applicability of that scheme, Millard. I am covered. Pension scheme, Millard, that has been reintroduced to us. Then, Millard, today, when I filed an application before the authority, that you see 1997 selection, and immediately thereafter, when we came to know about the cancellation, we applied before you, and ultimately, it is not that we are sitting on the fence and watching the proceeding. Continuous ultimately ended in 29 January 2014. So, normally the claim presented on the day when I approached the Honorable Tribunal, it ultimately ended on 29th January 2014. I am entitled to pay for a notional benefit, adding Millard amount to the pension. The tribunal, Millard, after considering my claim, Millard said, no. The reason, Millard, wait with the tribunal worker.
But the tribunal gave you a relief which did not specify that it was to relate back to any.
No, tribunal, Millard, question is, Millard, normally, many a times, Millard, this Honorable Court said it is a duty of the court or the tribunal to decide the dispute or the issues raised before it. Page number, Millard, 183, that is the order, Millard, passed by the tribunal.
No, before we
Tribunal says, Millard, the from the notification, the last 2 pages, Millard, 187, I am reading for my lords. 187. 187, 5.1.
Yes.
Heard both sides at length, perused materials on record. The applicants appeared in the written examination for appointment of the post of enquiry cum reservation clerk and commercial clerk against employment notice dated such and such. After the conduct of the written examination, it was decided to cancel the entire process and issue a fresh notification. Honorable High Court, after considering the facts and submissions in the matter, directed the respondent as follows. The respondents will intimate to the petitioners the date of the interview by displaying the information on the website as well as by issuing a press notification sufficiently in advance and in any event within the 2 weeks from today. The interview, if necessary, must be held within 4 weeks from day. The petitioner will be communicated the result of such interview within 4 weeks thereafter. It is obvious that those petitioners who have obtained minimum qualifying marks or above in terms of the railway recruitment rules of 1997, rules in 1997, must be appointed against the vacancies which are available today. The appointment of the petitioners will be effected within 4 weeks after communicating the result of the interview to them. Now, my lord, the recruitment rules 1997 specifically mentioned, High Court relied upon, and kindly see his name, my lord, the interpretation of the Honorable Tribunal, my lord. Directions of the High Court were specific. Since the applicants had scored more than qualifying marks in the written examination held in 1987, they were to be offered appointment after interview if necessary. Also, the applicants were to be offered appointment against vacancy available in 2014. From the notification such and such 8 to 14 February 1997, it is clear that the selection process consisted of written examination followed by an interview. This fact was noted by the Honorable High Court while passing the order in WPCT number 53 of 2008, in which the respondents were directed to grant appointment to the applicants after taking their interview because the applicants admittedly did not face any interview. In fact, the results of the said written examination never declared the selection process was not completed till the Honorable High Court passed the order directing the authorities to grant appointment to the applicants after taking their interview, if necessary. The selection process which led to the appointment of the applicants cannot be considered to have completed with the written examination. Sorry. In the instant case, the process can be considered to have been completed even after only after the pre-appointment formalities like medical tests, etc. were completed. The process was completed in 2014. Therefore, the claim of the applicant for granting them national benefit, from 1999 is not tenable. We do not find merit in the contention of the respondents that since the applicants were appointed against vacancies at the time of there cannot be appointment retrospective effect. Let my respectful submission before your lordship, the tribunal has relied upon may I come back on Monday, minute?
Yes.
Monday.
Yes, take down. Due to paucity of time today. Due to paucity of time today.
Monday.